এই প্রীতম
Maybe in YouTube. Yes, sir. One humble prayer. Since 2 days are left, my lord, will allow any application for bail to be upgraded only on the ground of parity. Only on the grounds of parity. Any day on Monday or
You
Tuesday.
say parity, Mr. Vishwash. When the matter is taken up, the state will say no parity and we'll argue for half an hour on that. We have seen this. We have experienced this. No upgradation, please. Accepting very bad health condition, bereavement. Accepting this.
Your Lordship, if I may permit it, Your Lordship, the petitioner is suffering from hepatitis B, and I had sought leave on 18th. Your Lordship had granted leave, and it was listed in the 19th itself as item number 219. Your Lordship, today it's 849. If it could be urgently taken up on Tuesday, it's a POXO case. Allegations in the FIR are of 498A, but sections have been
Very
given
well.
to POSCO.
If
Her
we-
sister had
If we
died.
don't find urgency, we'll adjourn it for 1 year.
Your Lordship, it is very urgent. His weight has decreased around 5 to
mentioned,
7
okay.
kgs, Your Lordship.
my lord, may I permit?
To be mentioned Monday.
May I permit to
Yes, my
mention,
lord.
my lord?
Inform the state council.
Yes.
May I permit to mention item number 699, my lord? This is a POXO matter, my lord. For a defect to present, my lord. When I inform the state.
Matter has been compromised practically. Well, the complaint is coming every day, my lord. He's a handicapped person. Well, they want to get married, my lord.
If your lordship, my lord. My lord, victim also present, my lord.
You have lodged this false complaint.
No, not false.
Not false. Then
Not false.
why is the provision for compromising? Why is the provision for compromising? Then
But kindly consider, my lord. My lord, costly more than 160 days, my lord.
then everybody will come and say.
I never approached before your lordship this kind of submission, my lord. This first time, my lord.
Your Lordship, may
No.
Your Lordship, may I be permitted to mention one matter for upgradation? It is for application of bail. The petitioner herein has already suffered a custody of around 120 days, and he just had a baby, newborn baby. His wife is suffering from postpartum depression, so there is no one else to take care of her. So, if your Lordship may permit to upgrade this matter, it is running in the list since the month of November. So, since the business of the Lordship didn't permit to take up the matter. Your Lordship, it is running in the list in 349.
What is the allegation against you?
Your Lordship, the allegation here is that the accused herein is a Mizoram citizen, and
NDPS.
no, Your Lordship. It's a Foreigners Act, application of bail of Foreigners Act. Yes, Your Lordship. He is a Myanmar citizen, but he is accused of being a Mizoram citizenship. Yes, Your Lordship, he is a Mizoram citizenship, but he has been accused of Myanmar citizenship.
Indian.
Yes, Your Lordship, he is an Indian, but he has been accused of being a foreigner. He has also been charged. He was arrested from NSCBI airport.
But may I permission mention my item number 300, the petition is in custody more than 8 years, almost 9 years. Last question, before Puja vacation was mentioned, the matter was fixed and
To be mentioned Monday.
My lord,
That
item
policy.
715, lordship passed one of the accused granted a bail for delay ground, lordship. For delay ground, lordship.
Yes.
4 years.
You are claiming parity.
Same footings. Both are same footing. two a person in the custody, lordship, one is
No,
allowed,
no.
lordship.
For relaxation of the condition of
দিচ্ছি না, দিচ্ছি না।
relaxation
Same
of condition
condition.
of bail, my lord.
Relaxation, you file it, it won't be taken up before vacation. File it.
Two mentionings. One is, is there any relaxation for upgradation for a lady accused?
Relaxation won't be taken
No,
up this time.
upgradation for a lady accused is your lordship, female
As of today, no,
No.
but in the new year, we don't know.
your
We might have a changed mindset.
grateful to lordship. But second prayer, my lord, item number 258. This matter was earlier upgraded by your lordship since one of the day, my lord, the list collapsed. Thereafter, my lord, the matter was appearing on the top of the list in the miscellaneous applications, but somehow, my lord, it has gone down. Can I pray in the same position? Because last day, my lord, it was taken up when it was a Tuesday,
Could it go down?
but it
It
has
must
gone
be
down.
because nobody appeared when
No,
it
no,
was
no,
called.
no, my lord. This was heard on last Tuesday when the matter was supposed to be
এই চেক করে নাও উনি যেটা বলছেন, যদি
258.
যদি দেখে নাও, চেক করে দেখবে, we'll see.
না।
Yeah. Call the list.
Habeas corpus, my lord, very interesting case, my lord. Husband is present, my lord. Wife,
I am for the petitioner, my lord.
My lord, I appear for the respondent family members against whom the allegations were made.
my lord, statement of this, my lord, husband.
What is the case? You don't understand.
My lord, the wife had alleged that the family members of the husband had kidnapped the husband.
And you are appearing for whom?
I am appearing for the family members, family members, the father, mother, and the other family members of the corpus, my lord. My lord, absolutely false, frivolous.
For the petitioner. I am for the
Husband
petitioner.
has been kidnapped, husband has been abducted.
That is the allegation of the wife against the
আমাদের-
family members of the husband.
Meena Kumari Shaw,
Yes.
victim girl, yet to be recovered. This is the last
No,
order.
no, not victim girl.
That is the last order, Mr. Mukherjee.
That's the typographical error, my lord.
Already recovered.
My lord, he was not recovered. He had came to know that there is a proceeding pending. He has contacted his family members and appointed an advocate for that, and has come before
What
this court.
remains in the habeas corpus?
Nothing, my lord. Only thing, my lord,
But what is intriguing is it is who went missing, man or
the
lady or
husband, the husband. He is
You
here,
see?
my lord.
have you seen last day's order?
Yes, my lord. It could not be corrected because the matter did not come in the list.
Victim girl yet to be recovered.
Then correction is required.
না না ঠিক আছে, পিটিশনে যদি বলা যায়। This
Well,
habeas corpus writ petition was filed by
The wife
the wife
on
of
false.
a person who apparently went missing, claiming issuance of a writ of habeas corpus. Stop. Paragraph. We have heard learned counsel for the parties today. Stop. You are filing some report.
My lord, kindly, my lord, 164 statement of this, my lord, husband.
Lordship will consider the statement.
There is a criminal case going on.
One criminal case has been lodged by the wife. Why, my lord?
The missing person is the husband of the petitioner. Stop. It appears that a criminal case has been initiated against the missing person on the basis of complaint lodged by his wife. What type of complaint?
Missing person and against the,
Family
my lord, against the family members, against
Oh,
us.
Acha. Alleging
Harassment, my lord, abduction and kidnapping and number of other baseless allegations, my lord. If your lordship takes up the statement of the corpus, my lord, your lordship will see it is the wife who created.
of the victim girl.
Statement of the VG. Statement.
Treatment of VG.
Sundip Jaiswal. Name is Sundip Jaiswal.
What is happening?
My lord, I don't have a copy of that. It was recorded on
But now,
23rd of October.
No. Against the family members of the missing person on the basis of a complaint lodged by the wife of the missing person, who is the present petitioner. Stop. She has alleged that the family members of her husband has abducted or caused abduction of her husband. Stop. Paragraph. The state has filed in court today. এই তুমি প্রত্যেকটা সেন্টেন্স কিন্তু প্যারাগ্রাফ করো না, আমি যখন প্যারাগ্রাফ বলবো তখন। The state has filed in court today. এটা প্যারা হবে। Statement of the
আমার কাছেও
so-called missing person being Sandeep Jaiswal, recorded under section 164 CRPC in connection with the aforesaid criminal case. Stop. From that statement, it appears that Sandeep was apparently driven out of the matrimonial home by his wife, and he roams around like a vagabond. Stop. There's huge marital discord between Sandeep and his wife. Stop. He stated before the magistrate that he doesn't want to live with anybody and he wants to stay on his own. Stop. Paragraph. It therefore appears that Sandeep cannot be said to be a missing person anymore. Stop. He has been traced out. Stop.
My lord, may I add a factual backdrop? My lord, may I make a small submission? My lord, the submission of the husband that he wants to stay on his own is because of a fact that his
We are not
paternal
concerned.
house, there is an
Because
order.
we are not concerned with the merits at all.
Deeply.
It has been recorded in the 164
That is what we have said.
Because there is an order pending against him.
We are
Gulam.
recording 164 statements.
Stop. Out. Stop. In fact, he is present in court today and has been identified by learned state counsel and by the investigating officer of the aforesaid criminal case. Paragraph. In that view of the matter, there can be no reason for keeping this writ petition pending. Stop. The writ petition accordingly stands disposed of.
Absolutely frivolous. My lord, some
Copies filed by the state.
terms should be put on the petitioner for putting the family to so much of trouble.
Chalo.
We are at liberty to take appropriate action under law without any specific order from us.
আরেকটা আসছে।
Who I am for the petition, my lord. My lord, this petitioner was granted bail by your lordship on 7th of October 2024. My lord, subsequently, it turned out that there were two cases, and the second case where I was named was tagged with the first one. Your lordship on the last occasion wanted to peruse the case diary and call for both the case diaries. My lord, these are the orders.
Sir, you did not stop. You see that whether file is reached to us, whether your other side reaches there, you started arguing. Petitioner claims vanity citing various order of the whereby expense out of in particular he laid order dated due to the So this is the dome call PS case number 608. It has been falsely, it has been incorrectly recorded here.
My lord. But in the course,
Just a minute,
it
just
was
a
a
minute.
mistake on the part of the,
It has been incorrectly recorded in order dated 7/10/2024.
it is a mistake on the part of the advocate who has, my lord, but
If you commit mistake, how can
Hello.
it be done?
it was the,
Now there is a different case 608 and
my lord, 608 has been tagged with 384,
just a minute. 384 of what?
2019.
No. PS case number
Don't call PS case 384 of 2019.
384 of 2029.
2019. 2019.
2019. Yes. So you are saying that this order should be passed in 384 2019.
My lord, that is the reason, my lord, the release order is not being able to be obtained, my lord.
Please give answer to my question.
My lord, 384.
384.
384.
Now, where is your petition for correction?
My lord, I filed the CRAN application.
Can apply the grant. So,
My lord, paragraph 9.
can application. কোথায় গো? আমি দেখছি নতুন আমি জানি না। So have you gone through CRAN application?
Yes, my lord, I have
So
gone
you have
through,
no
my lord.
objection?
My lord, one is 384 dated 16 June 2019, and another is, my lord, 608 to 2019 dated
384 dated.
My lord, dated
16th June 2019.
This is
19.
Yes.
Another is, my lord, 608 to 2019 dated 28th August 2019, my lord.
2019.
My lord, both are tagged together, my lord, on 4th September, my lord. That is true, my lord. And after that, charges, one single charges have been submitted, my lord. And now,
He claims parity.
the parity not, no, yes, my lord. That is true, my lord. The parity is there, my lord.
So if we change the
Now they have changed to the
Second.
case number, my lord. Instead of 608 dated 28th August, that should be 384 dated 16th June. That is their claim.
if we correct this cost title, then there will be no problem.
I don't think so, my lord.
But these
But because the same case, my lord, and both case has been tagged together, my lord. Trial is already commenced, my lord, and it has been going on.
Now they are claiming parity of which order? They are claiming parity of which order?
my lord, Raja Bhalsana.
Yes, show us. Show us.
My lord, from the petition,
Must be ready.
my lord, I have the order sheets, my lord. In 608, my lord, these orders were passed.
23rd August. Bond ধরিয়ে দিল। Bond ধরিয়ে দিলে হবে? কোন অর্ডারের প্যারিটি চাইছেন? প্যারিটি
এটা 608 384 এ কোনটাতে হয়েছে সেটা আমাদের কাছে,
যেটা প্যারিটি চাইছে
যেটাতে 384 এ অর্ডার হয়েছে সেটাতে আমাদের কাছে থাকবে না, তোদের কাছে থাকবে।
প্যারিটি অফ which order?
Hello, these are all the,
All these you have to answer. Come back after reopening.
If you don't come with after doing
my lord,
homework,
my lord, page, my lord,
After
my lord, page
reopening.
24. My lord, page 24 of the petition, my lord.
prepare yourself, come back on Monday. Not today.
To be mentioned here also.
My lord,
It's time for everybody. For yourself, for the court, for your brothers also.
my lord, page 24 of,
Most unhappy state of affairs. Yes, not today.
Ma'am.
Come back.
And for the state election.
কিচ্ছু দেখে আসলে এখানে এসে প্রিপেয়ার্ড হবে।
আমাদের দেখতে ওই
একটু দিয়ে
My lord, I'm in custody for 3
Correct.
I'm in custody for 9 years, 3 months. My lord, on not on that point, but the evidences are over. But my lord, arguments have started.
December
Last date,
13,
we have
sir,
taken time.
who has,
Defense has taken time. But next date has been fixed on 13th of January for further arguments.
so,
I was-
so prosecution argument is complete.
Yes, Your Lordship.
So now the ball is in your court.
May I pray for interim bail?
Why?
9 years, 3 months in custody, my lord.
23 people have died, Your
You
Lordship.
complete. If you argue for 3 months, then
No, but we'll finish it off.
finish it off. We'll keep it immediately after 13 January. Finish it off.
And there will judge me.
Bas. Learned advocate for the petitioner very fairly tells us that on December 13, 2024, some argument was made
Yes, my lord, some argument. No,
No argument.
no argument.
that on December 13, 2024, which was the date fixed for defense argument, adjournment was obtained on behalf of the defense. Stop. The next date fixed is
13th of January 2025.
January 13, 2025. Paragraph lists this matter once again on January 16, 2025. So upon that date, learned advocates for the party shall apprise us of the current status of the trial.
Deeply appreciated.
I am for the petitioner. On the last occasion, my lord, Your Lordship was pleased and extend the interim order, my lord. I am the unfortunate father of the deceased, my lord. Lord. My name is not mentioned in the FIR. Thereafter, charge sheet is my name is involved. Whose name mentioned in the FIR? His name is discharged.
My lord, on the last occasion, a report was submitted, my lord, on our part. This person was not initially named in the FIR, but he's the charge sheeted accused, my lord. And yes, he happens to be the father of the deceased.
How long he is in custody?
My lord, that time he was in 106 day custody, my lord. On got bail, that time he was in 106.
So
Charge sheet submitted.
we are closing down very soon.
Madam.
This interim order is till today.
My lord.
We'll extend it till the end of January and we'll hear out the matter in January.
My lord.
Okay, sure. The order of interim bail that the petitioner is enjoying, is operative till today. Stop. We are very close to the Christmas vacation. Stop. It is not possible for us to dispose of this bail application on merits. Paragraph, let the interim order of interim bail continue till the end of January, 2025, or until further order, whichever is earlier. Paragraph, list this matter once again. Tell us, first week of January, on January
Well,
3?
January or February, because 31st January, the marriage.
Interim bail is till 31st January. Before that, we'll dispose of. Either we'll confirm or we'll dismiss the bail application. January 3rd January.
Madam. Grateful, Lord.
না না চল
Grateful, Lord.
আমাদের ওইটা
Item 5,
So far, item number 6 is concerned, my lord.
I am for the item
My lord,
number
your
6.
lordship was granted interim bail. After grant of interim bail, we have examined one of the IO in part, and the remaining part of that IO and another, the second IO, is fixed on 4th. In a similar matter, your lordship has fixed the matter on 27th of January, thereby extending the interim order yesterday. So, my lord, let this matter be listed on 27th, and my lord will extend the interim order.
Let me understand. Arman Sheikh has been granted bail.
Yes.
Interim bail.
Yes.
So Tanmoy
Tanmay is the manager.
Tanmay is also enjoying
No,
interim
no,
bail.
no, Lordship, he is
So Tanmay wants interim
wants
bail.
interim bail.
Why? What is the ground?
Why? Same footing.
My lord,
Granted interim bail lordship on the ground of delay lordship. Both are arrested on the same day lordship.
Oh, I see. How much? What period of detention?
4 year, 5 months more than.
So therefore, they on the same logic.
Yes, yes. All of both.
Where is that Arman's order you have?
Yes, lordship. I have annexed that order,
Yes.
lordship. Page 20 lordship.
Page?
My application lordship.
Yeah,
20 lordship.
petition.
416.
Ah. Yes. Police case number 620. একই police case তো?
6 নম্বরটা কি আছে?
No,
Well done for the state, your lordship. On the last occasion also, the petitioner did not appear. My lord, the case is fixed for judgment in the lower court today, your lordship.
Correct, correct. We
Yes,
remember
your
now.
lordship.
It's
So-
actually cool. Yeah. Hey, thou. On December 17, 2024, this matter was called on for hearing. Stop. Nobody appeared for the petitioner. Stop. Learned state advocate apprised us that December 20, 2024, i.e., today, has been fixed by the learned trial court as the date for pronouncement of judgment. Stop. Accordingly, we had directed this matter to be listed today. Paragraph. Today also nobody appears for the petitioner. Stop. CRM DB 3019 is dismissed.
Nice, my lord, I am appearing for the petitioner. Case under section 376, my lord, 417, 420, 313, my lord, 34 of the Indian Penal Code. My lord, 98 days is in custody. The
Why
both
has
are
it been fixed at the
complainant
top?
and the accused petitioner, my lord, are advocates. My lord,
My lord, de facto complainant is
yes.
also an advocate, petitioner is also an advocate. My lord, they have a, my lord, romantic relationship, no doubt about this, my lord, I admit it. But the thing is, my lord, he is suppressing that he has a baby boy, and my lord, his divorce was not complete.
হ্যাঁ হ্যাঁ বন্ধ করে দাও Yes, Mr. Banerjee.
My lord, in this case, he was one of the accused of a.
He was not there in the night.
I'm telling my lord, in that house.
Nobody was there.
No, there is some person are there. They have fled away from the place.
He had broken open the
Lock and entered.
Yes, man, not broken open.
provision. So
We entered the house in connection with the case of NDPS of 2018, where he was absconding to find him out. We have an information, we lost the
just
TT,
ceased
and
it.
thereafter we entered the house. And there, my lord, we found these things, my lord, these contraband, my lord. And hence this case has been started. And his case has been started in 2020.
no independent witness.
My lord, in the night, in the midnight,
Why you have taken this?
because
You could have entered in.
no, my lord, because we have the information that he is absconding of the case of 2018 of one of the NDPS case that has been mentioned in the FIR also.
No.
And to apprehend
How
him,
do we know it was not planted?
Huh?
How do we know it was not planted?
my lord, there is evidence is going on, my lord. In that respect, my lord, there is no such. Then, my lord, we will produce the copy of the deposition. Whether they have stated.
I have the evidence, my lord. What is this?
Have you gone through
Read it and then give us.
No,
No, my lord. Well, the FIR says about nobody was in the house.
no, my
So
lord.
there can't be much more than that.
My lord, kindly see,
My lord, I mean, custody says February.
February, but absconding for 4 years. That is
My lord,
not
that is 18. I'm giving the lordship. The
How
charge
many
sheet was.
witnesses have been examined?
till now, my lord, 4 witnesses has been examined.
Out of?
We will examine more 4. Out of 8, my lord, 4 has been examined already.
Deposition group নিয়ে নেবো চারজন।
নিয়ে দেখতে হবে।
Give us depositions of the witnesses so far examined.
Yes, I've
Let us
given it.
study them. All 4.
All 4.
Sorry, the four.
What? All 4?
Only one.
Only one.
Only one, two. Only
No, it is the FIR.
Oh, there are four.
4 in there, man. Lordship, well, there's a question of, but then I would have been arrested on the spot.
Have you gone
No, I don't have.
But I would have been arrested on the spot itself then.
No, he had fled away.
Are fled away. But can your lordship believe this? A police officer says this is Milord Mukherjee's bedroom. How can he say that, my lord?
Let us consider, give him copies also.
My lord.
Come back on Tuesday.
My lord.
Another thing expired.
My lord, in 365 of 80, 365 of 80, I have been discharged. Not charge sheet, I've given the certified copy.
And expiry.
Expiry date, my lord, 22 it expired. On 23, the examination is being done. What remains, my lord? I'm not asking for quashing.
Just a minute. Allow.
Sorry, my lord.
So you have seized the cup syrup when?
20.
And you send in 21.
My lord, the
For
problem is
chemical.
at that point of time, my lord, COVID protocol was there, and that is why the delay, my lord. My lord, kindly make it on Tuesday, my lord. I will.
No, I'll be grateful if your lordship disposes because I won't be coming from tomorrow.
What do you want to see?
My lord, I want to see the deposition once, my lord, because they have not taken.
Right now, not long.
Come back at 2 p.m. Go through it, come back at 2 p.m.
Right.
He wants to see how can we say no.
But it's his document. He's the prosecution. He has to give it to the court, not me.
We don't have this copy.
We are telling you, Mr. Banerjee, this is a case. Normally, we are strict, this NDPS thing, unless it's Article 21. But this is glaring.
আমি আসছি না
2 p.m.
2 p.m. come. You're there at 2 p.m.
No, I'm not there.
Then what is that?
Go through. Pass over for 10 minutes.
What will you go through? Go through.
দেখে নে না
আপনি ওটা করে
Pass over, চলো।
দাঁড়া 1 মিনিট আচ্ছা কিছু নেই আমি বলছি তোকে কথা শুনবি তো না তোকে আমি কেন unnecessary well he's read it my lord he's not got anything my lord
I will at 2 p.m.
no I won't
Not there.
After 10 minutes.
Yeah.
এটা কি রিপোর্ট দেখছি
Forest.
oh হ্যাঁ my report was called in the next matter my lord this is the last order which was passed by the learned court below my lord I'm in custody since October 22 warrant has been issued
রোজগার বন্ধ করে দিলি একটা বড়। My lord, may I submit only one thing, my lord? In connection with this case,
What is this?
my lord,
Topujul Islam Lashkar.
Topijul Islam Lashkar, my lord, I have produced the order last time, my lord. He is the co-accused, standing with the same footing. My lord have rejected his prayer with the direction to conclude the trial within 6 months, my lord. And as per the report, my lord, we will complete.
My lord, when was the 6 months, when did it expire, my lord?
Hasn't expired.
Yes, in the month of February.
August 23rd order for 6 months.
No, my lord, sees the warrant of arrest has been issued against the witnesses for not coming. And sees the date, my lord. I've given it, I had only one copy, my lord. Warrant of arrest has been issued. And my lord, here the worst part is, these are all public servants, witnesses.
Yes, Mr. Mukherjee, they have time till 23rd of February. As per this order.
No, I can't say.
What do you propose to do?
But give an order saying, quoting that order.
You can, in view of this,
Yes, in view of this, my lord,
you can withdraw with liberty to file a fresh.
my lord, the clients don't understand
Okay,
that.
very well. Yes, sure.
They think, my lord, we manage the state and everything.
Status report filed by the state be kept with the
My lord,
record.
can I have that order sheet?
Any
Take
order
it down
to-
now, order. Oh, my lord, I've got it.
Be kept with the records. Stop. Paragraph. The state says that the bail prayer of a co-accused person, namely Topojul Islam Lashkar, was rejected by this bench on August 23, 2024 in CRM NDPS 1285 of 2024 with a direction on the learned trial court
My lord, may I leave, my lord? I have 10 minutes to chale jabe to.
to expedite the trial to the fullest extent possible and conclude the same at an early date, positively within 6 months from the next date fixed for recording of evidence. Stop. The state says that the trial will be concluded within the time period indicated in the aforesaid order dated August 23, 2024. Paragraph. Learned senior counsel appearing for the petitioner says that he had no knowledge of the aforesaid order. Stop. He has very fairly left the matter to the court, discretion of the court. Paragraph. Since this court granted a time frame, prescribed a time frame within which the learned trial court was directed to conclude the trial, and since time is still left for the trial court to conclude the trial, we are not inclined to entertain the petitioner's prayer for bail, at this stage. Paragraph. Accordingly dismissed. Stop.
I'm for the petition.
Report, my lord. All the witnesses already been examined.
All witnesses?
All. Next date is fixed for 13 on 13th of January 2025. I filed the report.
Handicapped person kindly consider and to rider who fled away the spot, he has been granted. And
yes, it will conclude soon. 313 is 9th January.
January is for a date fixed for 313 million.
Handicapped person cannot engage in drug peddling.
My lord, who has been fled away from the spot, he has
Mr. Mahapatra is laughing.
the order said.
We shall acquit you.
Chalo, issue. Status report filed.
Incriminating statement against you, material against you.
Have you gone through the depositions?
But
He had requested you to go through the deposition.
Yes, my lord, I have received in just now, my lord.
Just
in
now?
the morning, my lord.
Oh.
In 2 p.m.
No, to be mentioned Monday. Oh, no, Monday. No.
But anyway, it will be.
Why you supplied now?
But he has not, I have asked for, he has not supplied.
I apply for, but that copy not. Monday 2
All the, my lord, all the.
313 is fixed, date fixed. No, nothing. Kiva, while by the court be, by the state be kept with the records. Paragraph, we find that witness action has concluded. Stop. Recording of evidence is complete. Stop. January 9, 2025. 13, January 13, 2025, has been fixed as the date for examination under section 313 CRPC. Stop. Paragraph, since the trial is on the verge of conclusion and prima facie there is incriminating material on record as against the petitioner, we are not inclined to allow the petitioner's prayer for bail, at this stage. Paragraph dismissed.
But I for the petitioner. Well, kindly see your lordships. Mr. Roy is appearing. Well, kindly see your lordship's last order. 2nd December order.
Directly.
Yes.
My lord, if I may imitate Mr. Sudipto Moitro, my learned senior. My lord, this bail application has a checkered career. My lord, at first the argument was non-compliance of section 50. Then it was non-supply of copies under section 207. Now it has come down to default bail. My lord, your lordship, I am relying on the judgment delivered by the Supreme Court, reported in 1994, volume 5, SCC 410. I am referring to paragraph 53 at page 443. Your lordship will kindly come to subparagraph 2B appearing at page 445, 444.
Sanjay Dutt, yes, it's a well-known case.
2B. The indefeasible right of the accused to be released on bail in accordance with the provisions of the whatever it is, read with section 167(2) of the Code of Criminal Procedure. In default of completion of the investigation and filing of the challan within the time allowed, as held in Hitendra Vishnu Thakur, is a right which ensures to and is enforceable by the accused only from the time of default till the filing of the challan, and it does not survive or remain unforeseeable on the challan being filed. If the accused applies for bail under this provision on expiry of the period of 180 days or the extended period, as the case may be, then he has to be released on bail forthwith. The accused so released on bail may be arrested and committed to custody according to the provisions of the CRPC. The right of the accused to be released on bail after filing of the challan, notwithstanding the default in filing it within the time allowed, is governed from the time of filing of the challan only by the provisions relating to the grant of bail applicable at this stage.
Mr. Roy, this perhaps doesn't answer our query. Because filing of the challan, we take it means filing of the charge sheet, right?
No. In this case, what had happened is, after filing of the challan, the chemical examiner's report traveled straight to the court of the learned judge. The learned judge took note of it. Subsequent that, the supplementary charge sheet was filed with a copy of that chemical examiner's report Now,
till the filing of the
if your
supplementary,
lordship takes the entire scenario also together, including this bail application, nowhere your lordship will find that the accused has exercised its right under section 167(2) to be released on bail. My learned friend will kindly show a single paragraph,
no. 27th of September, this application was filed.
My lord will kindly take up that application.
No, this bail application.
Yes, kindly take up that bail application.
No, that nomenclature, Mr. Roy, is not important.
Then your lordship will record that on a verbal prayer, the accused can be released on bail without the accused saying so.
No, why? A bail application has
No,
been filed.
the accused has to make a right. Your lordship sees the judgment. Accused has to submit before the court. The statutory period has expired. I want to furnish bail bond.
Rakesh Pal is there. M. Ravindran is there. If I am not wrong, Uday Mohan Acharya.
Yes, kindly bring those judgments. Kindly bring
Rakesh
those
Pal is there,
judgments.
but
The right has to be
2nd
exercised.
of January. First
Right
week of
has to
Monday.
be exercised by the
Seriously.
accused.
Because 2nd of January, not many learned advocates are likely to be here. You'll be here, Mr.
I might be, but oh, my lord, not on the reopening date. Your lordship has a vast experience. We also have. We
Very
don't
well.
get over the hangover. Full court, this, that.
এই শোনো আজকে হচ্ছে এনডিপিএস আবার তাহলে রিওপেনিং ডেতে এনডিপিএস হবে 2 তারিখে
চেয়ে গেল
2 তারিখে এনডিপিএস তাহলে আবার এনডিপিএস কবে হবে রিওপেনিং এ করতে চায় না 3 6 7 7th January will be NDPS day. Come with all judgments.
Lordship. One judgment that he doesn't have to exercise his right.
We will, between the two of you, will take not more than half an hour.
No, I have concluded my argument. He has to show to your lordship that he has to exercise.
I'll take 15
If he
minutes.
doesn't,
15
goes.
minutes.
Very well. Then
That is
7th of January, 4 o'clock. Heard learned
Yes.
counsel for the parties. Stop.
This
A
is a
short
fine
but
judgment, judge.
interesting, a short but interesting question of law is involved. Stop. Paragraph to enable learned advocates to cite the decisions of court on the point involved, comma, let this matter be listed again on January 7, 2025, comma, marked 4 p.m.
This is slightly different. The report directly traveled to the court.
Directly travel to the court. The court had taken cognizance of
Only thing I want to know, does that become a part of the charge sheet by the report being directly sent to the court and the court receiving?
What the court takes, my lord, subject to correction by your lordships, cognizance is not a defined term. The police files their report. We say cognizance taken. That means the court applies its mind, finds a prima facie case against particular individuals being committed.
That makes sense.
Prior to this act, perhaps Mr. Mukherjee will correct me if I am not wrong, it was an offense. The offender used to be found. Now the offender is also before the court. The court takes cognizance of the offense that prima facie these persons are responsible for committing this offense. Now, if certain documents travels directly to the court by the expert, of course, 294, 295, I am thinking 293 and 294, I am thinking of making the state moving that application. These documents should be moved at the first instance and prayed for by the defense whether they want to dispute or not, so that the examination of these witnesses can be also dispensed with and the trial proceeds much more. My lord, already maybe Mr. Mukherjee is very much agreed by me. I have been able to ensure the police authorities that you cannot file charge sheet like this. That CBI practice will not do. And in our time also, you, my lord, your lordship perhaps has forgotten, but when I used to visit your lordship's house, of course, to meet Mr. Senior Banerjee, your lordship was also there in the matter. Your lordship had expressed your lordship's willingness to participate in some criminal proceedings. Unfortunately, I could not have had the, when I acquired the authority to engage any brief, your lordship has drifted in the other stream much ahead.
My lord, the irony is, my lord has not taken up the criminal matter when Dr. Taposh Banerjee's thesis was on criminal law. That's the irony of the entire thing.
No, Dr.
Nor
Banerjee,
did he practice criminal law ever.
No, I was just going to say that Dr. Banerjee was also not known for his for this.
I've never seen him,
His
but I've never
thesis
seen him.
was in that. My lord, this is
Only
Mr.
thing, Mr. Roy, he may be a little unhappy wherever he is, seeing that his only son has turned hardcore criminal now.
bad. My lord, late Mr. Bolaira told me, he used to call me in my pet name, that 90% of this profession is here. You are given 10%. In that 10%, you will have to give 200%. Both is required. But 90%, Mr. I'm saying, he used to tell me, Khokon, remember, is here. Mr. Basu told me when I first went with Mr. Mukherjee's brief to get it settled, he had given me, in 91, he had given me about 900 rupees. I said, this amount of money, he said, Mr. Devashish, if the eligibility was the criteria, then Mr. Deepak Sengupta would have been sitting in this place and I would have been sitting in that place. And there are many learned lawyers who knows much better than me, but my lord, God, touchwood, my learned seniors has bestowed me this.
There's another thing, my lord. One gentleman needs blessings from your lordship today. Mr. Ruddrodipto Nandi. Today is his birth.
He just got spared.
Many, many happy returns of the day.
My lord, he just got spared. And I had come with a foul mood today in the court.
But now
Ganguly just reminded me.
Kindly ask him what's my fault. My fault is I have forcefully sent him to AIMS for an entire body checkup. That's my
and
fault.
that he also skipped and come back. Saying I'll go again.
He has taken 1, 2 he has not done, and after that he has
And
fault.
kindly tell Mr. Nandi, and when my phone lands, you tell me at 5:30, 56 briefs have been allotted. What do I do? Kindly come early tomorrow to mention before Justice Bagchi.
No, but we are missing the main point. When is the party? May the Almighty bless you with abundant health, happiness, and peace of mind. Yes, next matter.
Well, Passover can be called.
Passover.
Sure. He's come.
Yes, what do you say?
PW2 is the investigating officer who submitted charge sheet. In the PW2 cross also stated that I did not collect any document.
So you examined PW2 at the very outset of a.
I leave it to your lordship now. There's nothing, man. I've gone through it.
Issue.
My lord, kindly. My lord, this is the report, my lord. As asked for, my lord.
Status report filed by the state be kept with the records. Stop. Paragraph. The facts of this case are a little peculiar. Stop. The police raided the house of the petitioner, broke open the padlock and allegedly seized 55 bottles of fencyl syrup containing codeine phosphate. Stop. This was sometime in the year 20. When was this?
2020.
Which date? What date? This was
Specific date I'll give you, lordship.
on blank 2020.
9th of May 2020.
May 9, 2020. আর কি কাগজ দিয়েছিল না যে কবে পাঠিয়েছিল কবে রিসিট
Well, in the report, my lord, it has been stated, my
Stop. The The sample allegedly collected from the seized articles was received by the State Drugs Control and Research Laboratory, Government of West Bengal, on September 14, 2021, as would appear from the certificate of test or analysis under the NDPS Act issued by the director of that laboratory. Stop. In other words, about 1 year, 4 months after the alleged seizure, the sample was sent to the laboratory. Stop. The sample was tested on March 2, 2023, i.e., almost 3 years after the alleged seizure. Stop. We find from the records that the syrup from which sample was allegedly drawn, expired in January 2022. Stop. Therefore, the testing was made much after the expiry of the period. Paragraph. Paragraph. That apart, there was nobody in the house when the seizure was made by the police. Stop. There is no independent witness to the seizure memo. Stop. Paragraph. 4 witnesses out of 8 charge sheet named witnesses have been examined already. Stop.
Investigating officer.
The investigating officer in cross-examination has stated as follows: colon দিয়ে কোট করো, এটা করে দেবে, এখানে যেটা দাগ মারা আছে এটা কোট করে দিও. Paragraph. In view of the aforesaid, there appear to be reasonable grounds for believing that the petitioner is not guilty of the offense he is charged with. Stop. Of course, this is a prima facie observation only for the purpose of disposing of this bail application, and this observation will have no bearing on the trial. On the trial. On the trial. Stop. Paragraph. We further see that 2 other NDPS cases were initiated against the petitioner. Stop. One of the cases ended in acquittal of the petitioner. Stop. In the other case, the petitioner was discharged. Stop.
Not sent, I give it.
Not sent up for
Not sent up in charge sheet.
That is.
My lordship, last page at the back, my lordship.
Stop.
Thank you.
Therefore, we are of the view that the petitioner is not likely to commit any offense while on bail. Stop. Paragraph. In view of the aforesaid, the restriction in section 37 of the NDPS Act stands rebutted. Stop. The petitioner is in custody for
Since February.
since February
10 months.
2024. Stop. We are inclined to allow the petitioner's prayer for bail.
Prima facie observation.
Prima facie.
All observations in bail orders are prima facie.
My lord, only one thing, my lord. The one condition should be there because, my lord, he is absconding.
No, tell us.
my lord, to meet the investigating officer.
Are kotha investigating officer?
No, the
OC boss?
OC, my lord.
Yes.
OC, once in
Which police station?
Gangarampur.
Gangarampur police station.
Once every week?
Yes.
Yes.
And attend every trial?
Yes.
Yes.
Of
right.
course. That is always there.
Grateful.
Discharge from that.
365 মানে 2018 কেস ওই কাগজটা দাও আমাকে ডিসচার্জের
ওইটা না ওইটা থাকবে
ওই সার্টিফাইড কপি ওইটা থাকবে মাই লর্ড এতে আরেকটা আছে হ্যাঁ ওইটা এই 12টা বেজে গেছে এইটুকু হাসিস প্যানিক করে দিচ্ছি
I did to appear on behalf of the petitioner, my lord. My lord, 2 years, 7 months, I am custody, my lord. 32 bottles codeine recovered. Out of 13, 4 witness examined, my lord. Prior to framing of charge, 8 days prosecution took time. After framing of charge, 11 days prosecution took time. And my lord, on instruction, I am submitting on 9, 10, 11 was the date fixed for evidence. That day also took adjournment. And no independent witness in this.
My lord, kindly see who took time. This is the certified copy of the orders, my lord. I am showing the initial on framing of charge, my lord. Framing of charge, my lord, initially started on 14th February 2023, and we can able to frame the charge, my lord.
So what does it mean? Accused Santanu Gera Dhivar is produced from JC.
There.
Okay. Lanet PP in charge file Sajira. Today is fixed for consideration of charge. No steps taken by the defense counsel for the accused person. Accused has been produced before the court. What steps should have been taken?
My lord, kindly see all the cases, all the dates.
Whatever it may be,
All the dates.
if the accused is produced, then what steps?
Kindly see my page 22 onwards.
And my lord, kindly see the last schedule. Last schedule, my lord, 9th December, 10th December, 11th December. My lord, I have folded the page.
9 December. Today is fixed for evidence as per schedule. Accused Santanu Dhivar produced. Lanet if in charge and defense of witness is examined at PW for his cross-examined full. Then
10 and 12, 11.
Accused is produced. And it is presently by filing petition on the ground stated in the petition. Yeah, file a petition on 9/12/2024. What is the ground for filing petition?
Kindly see 10th. Next day.
Key. 231.
Witness is present, but
When advocate's mother was admitted in the hospital.
And
Well, kindly see page 32 onwards once.
if the mother is admitted in the hospital, how you can take this ground to tell?
Well, kindly see, my lord, prior to that 32 onwards, my 10 times prosecution took time. Page 32 onwards, kindly see, my lord. Out of 13, 4 examined, my lord. Kindly see my page 32 onwards, my lord.
Status report.
My lord.
What, my lord?
No,
Already
status report. Yes, my lord, I have given. This is the status report. And my lord, kindly see the antecedent of this person, my lord, from only one police station. 15 cases, my lord.
15.
My lord, kindly see the list.
Conviction?
Whenever he is on bail, my lord, another case has been registered.
how many witnesses you propose to examine? Have you read the report? You have not
Yes.
read the report.
No, I have read.
Yes.
My lord, out of 9, my lord, 4 has already been examined.
Out of 13, my
Out
lord.
of 30.
We are intent to examine 9 witnesses. Out of 9, 4 has already been
So
completed.
5 more you intend to
Yes,
examine.
my lord.
So what is the time frame?
No copy of the report was supplied to us.
You want to consider and come back?
My lord, yes, my lord. No copy of
Give
the
a copy.
My lord.
13 witness
No, my lord,
examined.
Till now,
Well-
total number of 4 witnesses were examined. Total number of 9 witnesses.
What are you saying?
9. My lord, kindly tell me.
4 already examined, 9 more to be examined. That is the report.
Yes, my lord.
My lord, kindly, my lord.
Oh, sorry, my lord.
My lord, kindly, my lord, once, my lord, page 31. Once, my lord, kindly.
Give him a copy of the
My
report.
lord.
Kindly page 31, my lord, kindly.
My lord, right.
Page 30.
Then we will not give you the report. We'll just pass an order. Status report filed by the state be kept with the records. Stop. Let a copy of the report be made available to Letna. A copy of the report has been made available to learned advocate for the petitioner in court today. Stop. Learned advocate for the petitioner seeks time to consider the same and come back. Paragraph. Reopening day. List the matter once again on January 2.
My lord, please kindly make it 6, my lord.
Huh?
Instead of 2, kindly make it 6, my lord. 6 does it. After
6. No, then 7.
7.
My lord. My lord, the certified copy of the
Of?
certified copy of the order, my lord. Should I keep it or kept it? Or?
You keep it with you.
My lord.
Ferot diye daw certificate.
My lord, I am for the petitioner. I am praying for bail on the ground of parity. One co-accused has been
Who is for
granted.
the state? You are for the state?
Well, kindly seize the order. 18. This is time first time. Okay.
They were supposed to hand over the copy of the depositions to us.
We have annexed.
কোথায়? Last order দেখো।
Have you given them?
হ্যাঁ আরেকটা যেটা ছিল কো-অ্যাকিউজ সে বেল পেয়ে গেছে সেম
লাস্ট অর্ডার দেখো বাবা।
আমার তো অ্যানেক্স করা পিটিশনে
I've been informed, my lord, that there was an order passed by this honorable court to hand over the copy of the depositions to.
Yes, that is the last order, 5th of December.
He says that it has been annexed. But if all is annexed, then why that order, my lord? I do not.
My lord, may I say, two matters were tagged together. In my petition, the depositions were annexed. In another matter, that was not annexed, and that I have handed the order before your lordship. He has been granted bail.
PPPB was different.
But then, my lord, I'll have to go through the depositions and come back to you, lordship.
Second reopening day.
My lord.
Copies of the deposition.
Instead of
copies-
reopening, oh, can it be the best?
7th. Copies of the depositions of the witnesses already examined have been made over by learned advocate for the petitioner
ওটাই সব তো?
to learned state counsel in court today. Stop. Learned state counsel seeks time to consider the same and come back. Paragraph lists this matter once again on January 7.
Gratefully.
জয়দীপদা
My lord, when I had filed this application, the date was fixed for production and charge on the 13th of November. I wouldn't know whether charge has been framed or not. Now, the second part of this, my lord, this case is very interesting in the sense, the only evidence against me is the statement of my elder brother, who happens to be the kingpin of this. Nothing recovered, nothing of the sort. I was in Assam jail, from where, my lord, I was brought to the.
Why you are in Assam jail?
And another NDPS case. Yes. Well, let's see, the record speaks for itself. I can't say much about it, my lord.
Charge sheet was filed on 16th August.
My lord, chemical examination report, my lord, we have received on 16th April 2024.
April na, August.
My lord, 16th April 2024.
Batai.
And my lord, that report was filed along with the charge sheet on 16th August
Very well.
2024.
Very well. So that
That
The
goes.
chapter is not there. No, I've not taken that point also. I can't take. Well, what is there, I must tell your lordship. My lord.
Nasir Gaji.
My lord, 8 days remand, police remand, nothing was recovered from me. My lord,
Caesar list?
nothing against me.
My lord, may I submit?
Yes.
My
Acha,
lord,
follow.
total recovery was 7 kg, 7.648 kg of morphine. My lord, it was recovered into 3 phases. My lord, there was a source information that huge quantity of contraband item arrived in Bahrampur. And my lord, the consignee was escaping. Thereafter, my lord, the concerned authority, my lord, deboarded the consignee from the Gitanjali Express in Howrah. And my lord, thereafter 67 notice was issued. Thereafter, his statement was recorded. On the basis of that statement, on the very next day, my lord, 2 persons were detained in Bahrampur. That is Guddu Sheikh and Safi Alam Sheikh. And my lord, there we have seized 4.095 kg of morphine. My lord, on this, as per the statement of Guddu Sheikh, my lord, Kamaluddin arrives, enters.
Asimuddin.
My lord, enters. My lord,
Interest means?
my lord, may I submit?
Enters
My lord,
the
4
picture.
kg was recovered along with one mobile phone of Guddu Sheikh. My lord, that mobile phone was sent for forensic. My lord, as per the statement of the Guddu Sheikh, my lord, it reveals that on 20th February 2024, just 48 prior to the seizure, my lord, 5,97,000 was deposited in the account of Kamaluddin.
I don't find it in the charge sheet.
My lord, I will
Sorry.
place all, my lord. And my lord,
It is the finding.
the account details of Kamaluddin was sent in a blank check. The photograph of a blank check, cancelled blank check, was sent through WhatsApp in the mobile of Guddu Seth. And my lord, the entire 5,97,000 deposited on the single day in part in the ATM cash deposit machine of Axis Bank, all the slips were taken photograph and was transferred through WhatsApp to Kamaluddin. My lord, the three persons are the supplier, that is the Kamaluddin. One is my lord Ashraf Hussain and one is Hasanuddin.
No.
And my lord, another thing,
I'll just show one
my
thing.
lord, two
I'll take it.
criminal cases are pending. Out of two cases, my lord, in both cases, initially he got bail. Thereafter, violating the condition, bail condition, he was again taken into the custody.
This
That
man,
is the SEPA, this person.
Well, I don't find it in the charge sheet. So if he's there, Malad, he must be saying from records. I have nothing to say. Only thing, Malad, is Malad just sees this. If your lordship feels, then Malad, I have no case. Just sees this.
No, this pertains to the present case.
Yes, the charge sheet.
If what he says is correct,
That is what I'm saying.
you
But
have
if he's born by records, Malad, I have nothing to say.
reached conditions of bail.
But I'll be honest with you. But I'm also an officer of the court. I can't ask certain things, Malad, which I can't. But if he's there, it record page to me. Cancel हुए आवर well then I have nothing to say. Malad, I have nothing to say, Malad. Only thing, Malad, that can expeditious then.
Yes.
Because technically nothing was recovered from me.
One more indulgence, my lord. On last occasion, my lord, we have submitted the draft charge. That is on 13 November 2024 before the learned court. But the learned court was busy in other judicial work, my lord. That is why, my lord, charge could not be framed. My lord, next date for charge is on 8 January 2025. But if your lordship kindly directs that the charge...
Yes.
That is what I'm saying. I'm telling your lordship at least.
Yes.
The petitioner says that he has been falsely implicated. Stop. There was no recovery of contraband items from him. Stop. He has been implicated on the basis of, solely on the basis of statements made by co-accused persons. Stop. He is in custody for?
From 19th of June.
He is in custody from June 19th.
My 6 months.
He's in custody for about 6 months. Stop. Charge is yet to be framed. Stop. He prays for bail. Paragraph. Learned State Counsel draws our attention to the material in the case diary. Stop. From CDRs and WhatsApp records, we find that prima facie there are sufficient incriminating material against this petitioner to indicate his involvement in the alleged crime. Stop. We are also told by Learned State Counsel that in other NDPS cases, this petitioner was granted bail, but bail stop. However, he breached conditions of bail and therefore the bail was cancelled and he was taken back into custody. Paragraph. In view of the aforesaid and in view of more than 7 kgs of morphine being involved in this case, we are not inclined to allow the petitioner's prayer for bail, at this stage. Paragraph. However, then next, we are told that January 9, January 8, 2025, has been fixed as the date for consideration of charge. Stop. We request the learned trial court to ensure that charge is framed on that day and the trial is expedited in general, in general, so that the same can be concluded on an early date.
Grateful.
Yes, not together.
that perhaps, my lord, that can be a joint player, my lord, because I'm sorry, my lord, the parties involved are the same, my lord, and in fact, my lord, the two cases are interrelated. So it can be taken up together because my lord, when I'll be making my submission, I'm sure, my lord, the report that they have also filed, my lord, is in respect of, my lord, same report in respect of both cases. So perhaps, my lord, lordship can, my lord.
Very well, let us see. Let us see.
Yes, lordship.
Separate contravention.
20.
Yes.
What was seized?
My lord, from, my lord, the petitioners, my lord, nothing. Nothing at all, my lord. But the petitioners, my lord.
How many
are
accused?
4, my lord.
Yes.
4 accused, my lord. My lord,
Deepa
I
Das
have
and
been arraigned as an
Father
accused, my
Jilam
lord.
Khan, right? Yes.
Yes, my lord. I have been arraigned as, or we've been arraigned as an accused, my lord, on the basis of an assumption that we would have committed a crime. That's the only assumption against us, my lord. Now, the petition number 1, my lord, is an old, my lord, a senior citizen, my lord, 63 years of age, my lord. Petition number 2, my lord, is a college student of 22 years of age, my lord. Lord, what has happened, my lord? On, my lord, 23rd of April, my lord, a consignment, my lord, was intercepted by, my lord, the NCB at the foreign post office. My lord, this
What post office?
foreign post office, my lord. Old post office. Foreign post office.
Where is that?
Old post office street.
Yes.
Strand Road, my lord, crossing, if your lordship sees, my lord. Now, my lord, this, my lord, parcel, my lord.
You should be at home and resting. You have got a bad cold.
My lord, but my lord, perhaps it's
You
my
should,
duty
you
that
should do
calls me
this
to
matter
court.
on the 2nd of January in the new year. Because your learned brothers are all exposed. Anyway, continue.
Apologies to my learned brethren, my lord.
Yes.
So, my lord, this consignment that is, my lord, intercepted at the foreign post office, my lord, has my name as the consignee and the phone number of one Bias. When I say, my lord, my name, my lord, it is the petition number 1. Petition number 2, my lord, has not come into the picture yet.
And what was there in that parcel?
Lord, MDMA tablets, my lord,
How much?
1.67 kg, my lord.
Huge quantity.
Huge quantity, my, much above the commercial quantity.
10 gram is above is the commercial quantity.
Saying so,
Above 10.
much above the commercial quantity, my lord, much above that, my lord. Now, my lord, on 23rd, when they intercept, my lord, they see my name, my lord. The phone number is of one Bias. Bias happens to be, my lord, my daughter, who, my lord, left, and my lord, daughter of petitioner number 1 and mother of petitioner number 2. She had, my lord, left us in the year 2000, went and settled in Mumbai, and then, my lord, married someone else, traveled to Delhi. Now she stays in Delhi. Now, my lord, this parcel, my lord, was opened by, my lord, the NCB on 23rd, my lord, and it was found, my lord, that in the parcel, my lord, MDMA tablets were contained.
Jilam is your granddaughter.
Jilam is the granddaughter of petitioner number 1. Correct. A student of, my lord, journalism.
Deepa Bias Jilam.
Deepa Bias Jilam. Correct. Yes, my lord. Now, my lord, since the name was contained in the, my name was contained as the consignee, so, well, since my name was there as the consignee, my lord, petition number 1, so they raid my house and, my lord, have a thorough search, season search, my lord. Nothing is found. Nothing is found. In the meantime, my lord, in respect of another case, where, my lord, on 18th of March 2024, that's prior to this case, my lord, 18th of March 2022, my lord, the contraband was seized by the customs. Case was registered, my lord, by the customs, my lord, which were after a month taken over by NCB, my lord, on 26th of April 2024.
This case.
No, not this case, my lord. In another case.
In another case against whom?
In another case, my lord, containing where, my lord, the name again, my lord, was that of mine as the consignee, petitioner number 1.
So you are a habitual consignee.
Yes. Absolutely.
Some people, just to falsely implicate you, sends drugs in your name as consignee.
There's more to it, my lord. There's
And
more to
that
it.
was recovered from post office or from your house?
That was recovered from the post office, not from my house.
So at that
In
time,
fact,
at that time you were informed or
yes, in fact, they came to my house with the parcel. They said there's a parcel in your name. I asked who's the consigner. Consigner was someone from Netherlands. I said I don't know about the person. I did not accept the consignment. I do not accept the consignment. Lord, because my lord, my name as a consignee
How
again
long are
appears
you in custody?
for more than 8 months, my lord. Almost 8 months,
What
4
is
days
the
less.
state charge framed?
Not framed. Charge sheet have been submitted, my lord. 8 October 2024.
what is it? They are not.
My lord,
You cannot.
one-
So, my lord,
they, my lord, these petitioner, my lord, admitted their, my lord, crime. They have given statement. Yes. My lord, 41, my lord, C, recorded, my lord, under section 67C of the NDPS Act. My lord, these petitioners, they have admitted their crime and they disclose that.
Before whom? Judicial
No,
confession.
Investigation officer.
Investigation. Is it admissible?
My lord, they have, my lord, stated that his, my lord,
Is it
daughter-
admissible?
No, my lord.
Then you have heard of Tufan Singh?
Yes. But they have, my lord, stated, my lord, that his, my lord, his daughter, yes, 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 my lord. His,
You are for the NCB.
yes, my lord.
And he-
His, my lord, next case, my lord, 2 consignment.
First case, he was arrested on 26/4,
This 20 or
24/4.
April,
CRM 1657, NDPS crime number 8 of 2024. It's his case. In my case, they were shown arrested on 29/4. Both same MDMA. What happened over here is parcel was intercepted by customs. Parcel was supposed to deliver in their house. They refused. It came back to customs. Whose name was imprinted over the parcel? Petitioner number 1. Petitioner number 1, grandmother, 2, granddaughter, 3, daughter of petitioner number 1, and 4, a Nigerian. 3 and 4 are in custody at Delhi. Same case, same narcotics.
No, you
This
say
is the racket.
parcel can be saying to only one person.
Petitioner number 1.
Why
I'm
three?
coming,
This
I'm
is not
coming
a,
to that.
it is not a plaint or something
Right,
like that.
absolutely.
Then you have to.
I bow down to your lordship.
That is also
Now,
peculiar.
29 attracted over here. 29 in NDPS is both abatement and conspiracy. Here, bank transaction, galore.
Yes.
Now I'm coming to that. CDR,
CDR.
galore. But my learned friend is not that much of habituated, so he forgot about 67. Who cares of 67? 67 is absolutely inadmissible. In order to attract 29, we have to give force on 2 things.
So there is bank transaction.
How conspiracy?
Bank transaction from Deepa Singh or
Yes,
something.
yes. All 4.
All four.
All four.
Let him show.
Yes.
Sure.
Let him show.
Yeah, you will see.
CDR.
CDR call, my lord. Report, my lord, page,
The report, my
page
lord, for
5, my lord,
CDR. If, my lord, the only thing that, my lord, will directly connect me, my lord,
last
is
location,
the
my lord.
CDR, my lord. My lord, if it was sent to FSL on 26th of April. It has been 8 months, my lord, the report has not come.
Mr. Huda.
Last
we
location, my
are
lord, report
not
has been.
deciding the trial.
Yes.
Bank
This
transaction.
is CDR details.
Yes.
Deepa Das, Jilam Khanna, Dias Khanna.
Calling to her. Calling to whom?
3.
3.
Among these 3.
Among these
CDR,
two. Yes, among these
along with
they are
this
relatives.
Maximus, who is
Yes.
Nigerian, accused number 4. There are 4 accused.
Who is calling that?
My lord, accused number-
All three.
Yes.
Yes.
Among all 3. This is the CDR details. And bank transaction, we have 7 pages. All these.
Account
With
Deepa.
Money going from whose account to?
Nigerian and then again Bias.
Oh.
So these are the racket, as I said, my lord.
Organized crime. Organized crime.
So section 29, abatement and conspiracy comes over here. Even
So
there
in both the cases, this is
Yes.
only one CD.
No, no, no.
I have
2 cases, 2
So as bank from your CD, so as bank transaction.
Lakshmi, kindly see, my lord, for both, my lord. Both.
is accused number 3 and 4 who are not before your lordship. They are in custody at Delhi. Same case.
So have you tried to who are sending these? Who are trying?
But someone from Netherlands.
You try to
এই report bank
not the position who are trying to implicate it. Somebody is sending
No, no, my lord. I am not for a moment saying that Bias is not involved. Bias, my daughter, I'm not for a moment trying to this.
You are saying that your daughter is involved.
Yes, 100% involved. In fact, my lord, when they
Representing bias.
no,
Oh.
no, when they came to me for the first time, my lord, when they came to me for the first time, my lord, the parcel contained my name and my phone number.
But Deepa gave birth to bias.
That's my crime.
Why?
That is my crime that I gave birth to Deepa.
Those bank transaction.
Lordship will see the bank transactions, my lord. Only saying, Lordship will kindly see. And my lord, well, Lordship will kindly see, Lord, what are the dates of the bank transactions?
260 don't know.
And my lord, Lordship will kindly appreciate that we are relatives. We are relatives. Not that, my lord.
Everything will be decided at the time of trial.
Absolutely, my lord. But my lord, my lord, what is my first case, my lord? Lordship will kindly.
You try to. If this is the position, then.
My lord, there.
Please allow us. Otherwise, we are.
Not false statements made, my lord, from the bar.
False statement. Who makes this? We shall verify.
Yes, Lordship will verify.
If they make any false statement, then bank account.
The case is, my lord,
Yes, that's registered. Yes, is not being represented.
No.
Yes, that's it.
I gave them the information about Bias. I told them about Bias.
Why the Deepa's account? Are you ready?
Yes, my lord. Next page, my lord, kindly see.
Next page.
Continuous, my lord.
Yes, you mark it and show us.
Yes,
You're handing up 500 pages and we have to find out.
Next
Lordship will kindly appreciate this, my lord. Their own, my lord, their charge sheet says, my lord, that in my.
Come back on the 2nd of January.
Lordship, my lord,
Otherwise, we'll reject it today, Mr. Huda. So come back on the 2nd of January. Let us see. We are trying to see, verify what they are saying is correct or not.
Absolutely incorrect, my lord, on facts.
We did not find till now Deepa.
But I am saying, my lord, from there.
Please, we did not find. With not you. We did not find Deepa's account right now. Okay.
Cholo, Kaushik.
Okay. 2nd January.
2nd January.
22 and
22, my lord, I am appealing for the NCB, my lord.
22, I am appealing for the petitioner. 22 and 23 are arising from the self-same case. Only the two petitioners are different. But if my learned senior is appearing in 23, he addresses your lordship, he's
I will be
20?
23. I'm appearing. 22, my learned brother is appearing.
Then give us 23 first.
But I can
address on both.
They're standing in the same footing, actually.
Tell us.
Same city.
Same city,
Yes, my lord. Same case.
শুরু করুন।
Complaint copy. Lordship will peruse the
From 22.
23. I'll address on both.
What is that?
These are the copies of the complaint given to us. I'll just take your lordships on the first 4 or 5 pages. That's it. Just the written complaint.
Written complaint. Who lost this?
Suomoto. The Suomoto complaint by the NCB officers. Second, 1, 2, 3. Third page, lordship, 4th page, the allegation starts.
এটা কি 23 নাকি 22 দিয়েছে? 23 টা মুভ করছে না। 23 টা নিতে হবে।
Paragraph 3 onwards. I'll address your lordship only on 3 grounds. That's it. Only on 3 points. Lordship will kindly bear me for a moment. Only on 3 points.
So you are Prabha Mundal.
How long are you in custody?
More than a year. More than a year. On the last date, they had submitted a report, a status report. Your lordship has directed them to serve upon a copy.
Yes.
We have received the copy, which shows that charges have not yet been framed. We are in custody for more than a year.
Yes, tell us.
My lord, paragraph 3 onwards. Lordship will kindly see paragraph 3. My lord, that the same was reduced into writing, and after intimating the same to the superior officer, necessary permission was obtained from the superior officers and team of NCB officers led by Tapon Shingo, intelligence officer, and other staffs, including one lady staff, left NCB office, Kolkata so and so, along with NCB. My lord, thereafter, paragraph 4 and paragraph 5 are the relevant. I'll be relying on that. Thereafter, Tapon Shingo requested RPF authority. They land in Howrah Station, platform number 8. Thereafter, Tapon Shingo requested RPF authority to assist them to nab suspected persons who are carrying contraband and shared the available information with RPF persons. Thereafter, NCB team reached platform number 8 of Howrah Station and requested some passengers and vendors who were available on platform to become independent witnesses for search, which is going to be conducted, but all refused to be independent witnesses. All refused. Then Taposh Shingo requested 2 RPF personals, namely Shri Raj Ranjan, Inspector of RPF Crime Intelligence Branch, Bardhaman, and Lady Constable Renu Orao, Howrah North Post, on which they voluntarily agreed or to become independent witnesses for the search. Then Tapon Shingo informed them about the information he had with them. So the independence of the independent witness does not remain.
It is unusual thing.
Absolutely, my lord. Raiding party.
All are
My lord, raiding party. Now they have been disclosed of what?
What
My
is
lord,
your
may I
next
say?
point, Mr. Vishwas? What is your next point?
My lord, next, my lord, the raiding party. What was going to get
Raiding
arrested?
party permanent, very well. Let's see your next point.
My lord, the second ground is, my lord, the arrest. They were the contrabands were seized on 12th.
You want to press this today or you want to come back on the 2nd? There may be a change of determination. You never know.
My lord, I am comfortable with your lordship.
Very good. Yes.
But I will take some time to address your lordships because there are 3 points.
Can't give you much time today.
My lord, I understand. That is the main problem. Because on the 3rd point, there was a mother judgment passed by the other coordinate bench regarding.
We can give you substantial time on the 2nd because on the reopening day, we do not expect many learned advocates to be here. Very simple.
Are you coming?
Yes.
Come on the 2nd.
But can it be fixed at 3 o'clock?
Yes, second, 12:45.
On second one of my brother has.
Oh, sorry. 2nd.
I'll just take some time of your lordship.
Come on the 2nd. It won't be fair to the other matters too.
I understand. But I will take some time.
You want 12:30?
But 12:30.
12:30, 2nd.
Grateful. I'm extremely grateful.
Even without an independent witness, a conviction can be sustained. If you read Nawaz Sharif, that refers to several documents.
Nawaz Sharif to
No, it refers to several judgments, previous judgments. In some of them, Chief Justice Chandra.
But that is your lordship relying on Nawaz that was passed in the year 2021.
22, 23, I can't remember.
21, but why am I relying on this? Because your lordship was pleased to grant bail on the similar occasions where the raiding party was the witness.
Yes, I know. That was
my lord, the question of independence.
On the principle of, or the basis of permanence.
Yes.
Remember, but at that time, these cases were not drawn to our attention.
But your lordship is asking for the judgment of Nawaz Sharif, which is of 2021, I presume, because yesterday
Nawaz Sharif has referred to several earlier decisions. Right. Those were not considered in permanent.
My lord, may I say this with deepest of respect? But few days back, the Honorable Supreme Court, within 10 months of custody, has granted bail to several NDPS matters.
142 is there. It's not available to us, Mr. Vishwas.
My lord, I will address your lordship.
Yes.
I'll try to satisfy. I know I'm in a bad footing. I'll try to satisfy. Come.
We are bad footing.
We. I'll come back.
Yes.
Item 25, not pressing this application, Your Lordship. I'm not pressing this application.
Not press করে দাও।
That's Your Lordship.
In item 25, my lord, I am for the petitioner. Uh, The petitioner was in custody for about, my lord, 8 months. My lord, the prosecution case is that, my lord, the source information rate was hit, and my lord, 2 persons fled away. And from the spot, my lord, 2 motorcycles were seized, and along with 200 bottles of fentanyl were seized. No person was seized from the spot. Thereafter, my lord, after,
Motorcycles are registered in whose name?
my lord, one of the motorcycle is registered in my name. Thereafter, my lord, after
No, case ends there, sir. As far as this bail application is concerned.
no, my lord, I am telling my lord why I am telling my lord. After 6 months, my lord, I was arrested from a resident. From a resident on the 1st of May, I was seized from my resident. And my lord, then my lord, on the first day, my lord, I was produced before the landed
Take information that how who seized your.
my lord, let me submit, my lord, something. My lord, let me submit. My lord, on the 1st May, my lord, that was the holiday. That is why, my lord, I was produced before the CGM. Thereafter, on the next day, my lord, I was produced before the original court. But the NDPS court is the original court of jurisdiction. Then, my lord, the kindly see, my lord, the FIR was lodged on 27th October 2023. 2023. Then, my lord, the FIR was not forwarded to the, my lord, the NDPS court, the original court of jurisdiction. That was forwarded before the landed ACGM. Thereafter, my lord, after 20 days, but the FIR was forwarded, my lord, by the landed ACGM to the, my lord, the NDPS court.
What prejudice is caused to you?
But that is why, my lord, I am paying call for a report, my lord, where the FIR was in the meantime, whether in the, my lord, the PS or, my lord, before the, my lord, landed ACGM. Because, my lord, my case is that, my lord, there is some concoction, my lord, because, my lord, the
File a status report, come back in January. File a
my lord,
status.
along with the, my lord, the cause of delay, my lord, for forwarding the report, my lord, FIR before the
Let him
landed,
argue, my lord, these all points in the trial,
No,
the
my lord.
divisional
Kindly,
court,
my lord,
not before
one
the
thing.
bail court, my lord.
No, my lord, one thing.
Time of consideration of charge.
Absolutely. It has charge has been framed, witness action is going on.
At the time of consideration of charge.
Well, kindly, where the FIR was? If the FIR was in PS, there, I have some case, my lord, because they may, my lord, concoct or develop the FIR according to their own will. Because, my lord, none was arrested from the spot.
How could we arrested? Everybody is absconding.
Maybe I was arrested, my
leaving
lord,
the
after 7
vehicle.
months. I was arrested after 7 months. The FIR was, my lord, my lord, running, my lord, for 20 days before, my lord, forwarding before the, my lord, landed NDPS court.
As soon as it is.
Absolutely, the law provides.
24 hours.
Kindly see, my lord, kindly see this order, my lord, first order, my lord. Kindly see. This is the first order of the landed ACGM, NDPS court. Kindly see. This is the order number 1.
Can take up all this matter at the time of consideration of charge. We cannot.
My lord, the person is, my lord, the custody for 8 months. The, my lord, they have violated the law.
No.
They, my lord, violated the. If the FIR is the PS for the long period, there is some doubt about the prosecution case. But my submission is that. But because of 20 days were already lapsed. Kindly, direct me to submit a report on that score, my lord.
Where have you stated in your petition all these things?
But this is the order sheet. Kindly see order sheet.
The petition, have you taken the point?
But though, my lord, that is not the point. This is the matter of record.
Who has drafted the petition?
My lord, if it is, my lord, bad draft, my lord, I have drafted the petition. If it is well drafted, but I have not. My lord, can you see the order sheet, my lord?
Sir, just file a report, whatever it was. The petitioner says that he is in custody for 8 months. Stop. Nothing was recovered from him. Stop. He has been falsely implicated. Stop. The FIR was sent belatedly to
About 20 days before the original court.
to the original court, having jurisdiction in the matter. Paragraph. Let the state file a report on the adjourned date, responding to the contentions made in the bail petition as also the submission recorded above. Paragraph lists this matter once again on January 10.
Yes.
January 10.
Obliged.
Forward করে petition file
Last occasion, my report was handed over to me. Now, Milad, kindly, I request you, like, kindly don't go by Milad quantum first. But I need Milad.
No, of course, we'll go by
No,
quantum
Milad.
also, not only quantum.
Milad, kindly, the first
88
instance, Milad,
kgs of
Lordship
gaja,
must
2
look into the
38
quantum, but
88 kgs of gaja from his car.
Milad, that's why, Milad, I'm saying, Milad, that
88 kg.
Caesar list says so.
Yes, and this is the last order.
I need 3 minutes, Milad, uninterrupted, Milad.
What? Why? Why should we give you even 1 minute? Caesar list says 80 kilos of
not only
gaja
that,
from you.
your lordship
I have
did
last occasion,
another
Milad.
accused.
The other points.
No, last occasion, Milad.
Kindly see
Milad,
the order of your lordship.
Milad, hear me,
On
Milad.
2nd
I have
December,
filed a
in
petition,
respect of
Milad.
accused number
Kindly hear me,
6.
Milad, for a minute, Milad.
How this could
If
deviate
they
from
start
this order?
arguing, Milad, I'll not make any
see this order.
argument, Milad.
Who accused?
Huh?
Well, I'll
Accused
not
number
make any
6.
argument if they argue, Milad.
Total 6 accused. This is
If they
accused number
complete,
6.
Milad, then I'll make my submission.
Petitioner is accused number 1.
Milad, may I?
Yes.
Now, Milad, this report, Milad, this is the second bail application at my instance, Milad. Milad, there is a difference between the report filed during the first rejection and the present report, Milad. And the difference is, Milad, fundamental. Milad, I consider this NDPS case, Milad, that my right to seek bail is, Milad, limited by section 37. Now, Milad, I have to satisfy your lordships that I can, Milad, make out a prima facie case that I am not guilty, though it's not a trial. Now, Milad, kindly see why I am saying so. Milad, kindly see the report filed at the first instance, Milad, while, Milad, the first rejection was done, Milad. Page 62, Milad. And Milad, this is a case where, Milad, I was arrested on 9th and I was produced before the court on 11th. So that is at the first instance, Milad, I was produced beyond 24 hours. 9th, I was arrested. According to them, at 3, I was produced on 11th. This is the first case, Milad. In terms of their record, not my statement. I have a next.
2 minutes more. 3 minutes, you said. 2 minutes. Yes. Next.
Milad, this is a case, Milad, where, Milad, that trust repose on the, Milad, the authorities is have been misused since, Milad, I have not submitted to their coercion, Milad.
Mr. Ahmed,
They have demanded money, Milad. Milad, kindly, I'll 2-3 records, Milad.
Mr. Ahmed, you have suffered a rejection on merits. On merits. Have you challenged that before the Supreme Court?
Milad, my right is there, Milad, to
Forget about
pray
that.
again.
Of course,
Milad,
you can pray every day.
Milad, I went to the Supreme Court, Milad.
Yes, rejected.
Supreme Court rejected it.
You should have told that at the very beginning.
Milad, even then, Milad, may I explain? Milad, all this one were not there, Milad. Milad, with the time, Milad, I filed a writ petition, only then, Milad, all these reports has come, and then only, Milad. Milad, kindly see, Milad.
6 prosecution witnesses, de facto complainant, the complainant over here, he has been.
Milad, I have not shown to you in a single record, Milad.
2024.
Milad, kindly
fixed on 7 January for further examination.
Milad, kindly see, Milad, 2 pages. Only 2 pages, I'll show, Milad,
I have been
stop my
taking time because non-production of
page
other-
36.
My lord, kindly have.
No, Mr. Watson. 2 pages, he said. We'll see 2 pages.
Rather, Milad, page 35 first.
Yes. No,
Paragraph
somewhere
7, first line.
Yes.
At about 13:45 hours near Amta, according to the first complaint they have made before the authority, that I was detained. Now, Milad, I made, Milad, RTI application at page 54. Because I was traveling, Milad, from Odisha to here. Now, let's kindly see page 54, question number 2. The time mentioned, Milad, Balibhasa Toll Plaza, this car that they have alleged at, Milad, Balibhasa to this place, Amta, at least takes, Milad, 3 hours. Milad, what they did, Milad, while rejecting, Milad, these records were not there with me. Milad, at the time of rejection of the first bail application, Milad, they have tried to, Milad, change the time. Milad, same authority, Milad, at page 62. But these submission I'm making, I understand. So all this point I can take in the trial. Now, section 37 says, prima facie, your lordship, if your lordship allows my application for bail, has to record a reason that I am not guilty prima facie. But that's why I am showing all these records that my petition is pending, and there I have sought for investigation against the conduct of the authorities. Now, I'll not make it.
How many charge sheet named witnesses? How many have been examined? Yeah, he is in custody for
almost 2 years.
22nd
That
July
my
charge
liberty is
was
being
framed.
curtailed at 71 years age. I may die in the custody
22nd July
without
charge was framed.
being proved that I am whether I am guilty or
November
not.
it started.
I am suffering a lot of disease. I have an X.
30th November evidence started. Complainant was examined. Next date is 7 January. Examination of complaint for
When will
cross
you
examination.
conclude? 2 years already in custody. File a status report.
Is there any criminal antecedent? Is there any criminal antecedent?
No, nothing.
Report doesn't say so.
File a status report, Mr.
Let me file a
Bhattacharya.
report.
Will you be coming to court on 2nd January?
Yes, my lord.
Will you be coming?
Yes, my lord. On 6th, it would be better because
If the lordship is there, I am always there.
officers with reports.
7th January.
7th.
You have been falsely implicated?
My lord, they demanded money on the way. They were with me, not in Amta. From Odisha, they were with
My
me.
lord, on 7th,
But I was traveling in their car, not in my car.
fix it after that.
7th?
On 7th is his examination.
Next
day.
examination. I see. 10th.
10th.
I was traveling in their car.
Yes, Mr. Amit. The petitioner renews his prayer for bail, which was rejected earlier on November 24, 2023. Stop. He says that he is in custody for about 2 years. Stop. Only 1 out of 6 charge sheet named witnesses has been examined. Stop. He is 71 years of age. Stop. He suffers from various ailments. Stop. He should be enlarged on bail as prima facie. There are several gaps in the prosecution case. Paragraph. Let your NCB.
NCB, my lord.
Let the Narcotics Control Bureau file a status report on the next date, indicating the delay complained of by the petitioner, indicating and explaining the delay. Stop. The report shall also indicate how many more witnesses the NCB intends to examine and an approximate time frame within which NCB expects the trial to conclude. Paragraph lists this matter. Now, let an advance copy of the status report be made available to learned advocate for the petitioner. Paragraph lists this matter once again on January 10, 2025.
I always leave with some, getting something from
Petitioner
That's
name,
right.
বলে লাভটা কি?
My lord, item number 42 pertains to another co-accused.
Who is for the petitioner in 42?
Petitioner
Petitioner is
Petitioner
Mr.
is not moving. Why you are?
অর্ডার করে দিন।
Chalo, next.
এখন দুটো অর্ডার দেওয়া আছে। অর্ডার দেওয়া আছে দুটো।
My lord, 4 persons were found in possession of commercial quantity of contraband exactly 2 years, 5 months and 5 days ago. My lord, they made these 4 persons, this was 4.7 kgs of opium. My lord, they made certain statements pursuant to which 2 other persons were arrested. Now, these 2 other persons who were arrested have been granted bail on ground of Article 21. Now, out of these 4 persons, 1 approached your lordship, and your lordship passed a direction. Now, paragraph 6 of your lordship's order.
কবেকার order?
17/9/2024.
No, this is the latest I've given.
Yes, that was not a bail on Article 21.
This is the
You-
latest one. And my lord, only
Mr. Mundi, you can submit. Let me finish.
only the cross of the investigating officer is
Right,
there.
my lord,
So your lordship directed that the persons we have been languishing in jail for more than 2 years, the trial be completed by the end of this year. My lord, as we stand, it is 6 witnesses have been examined. The charge sheet says about 23 witnesses, but from your lordship's order, I get that they want to examine 11 witnesses. This was submitted by the learned state on 17/9. Lordship sees. My lord, para 2 of your lordship's order, 17/9/2024.
17/9/2024.
2024, the order, my lord, I handed over.
Yes.
My lord, learned counsel for the state opposes the prayer for bail and submits the present petitioner does not stand on the same footing as other persons, etc. It is submitted that 6 witnesses have been already examined and 5 more witnesses.
Yes, Mr. Mehta, today Mr. Nondi says that only the cross of the last witness.
My lord,
being
we
the
are at
audio-
6, still at 6.
My lord, records my submission, keeps it on 8.
This was as in September.
Yes, my lord.
He says as of day.
This is
as
the
of date,
latest order of the lower court.
Only the cross-examination of the last witness remains.
And my lord, that is the number, my lord. May I ask him the number? PW?
PW 12, that is the last one.
My lord, PW 12. So, my lord, I take it, my lord, that after this there will be no examination. My lord, my lord, let me, very good, my lord, let me come back on 8th.
You come back.
After 8.
8th.
After 8.
10th.
10th.
The
Friday,
petitioner.
11, 12, 13.
Let them not take an
This is
adjournment.
your first
No, I have not taken any adjournment.
First application.
First application.
Just likho. We are told that the only cross-examination of the last prosecution witness being PW 12, bracket investigating officer, bracket closed, remains. Stop. The next date fixed is
8.
January 8, 2025. Paragraph as jointly suggested by the parties, let this matter be listed again on January 10, 2025, when we can, when the learned counsel shall apprise us of the status of the trial.
Extremely obliged.
দুটো রেখে দাও।
Item 29.
হ্যাঁ, কোথাও যাবে।
29, my lord, I am for the petitioner, my lord.
Not pressed.
No, not pressed, no, my lord. Initially, my lord, I have submitted that FSL report is not submitted late. My lord, that has been submitted. In my brief, that page got missed. I am tendering unconditional apology for that, my lord. Only one witness left. I am in custody for 2 years, 5 months. Only one witness.
Then what do you propose to do? Don't press it, because otherwise why suffer a rejection?
I am not pressing that.
Not pressed.
Great.
Lordship, kindly make it after
No,
vacation.
twice
After
early
vacation.
adjournment was taken. Lordship, they are trying to avoid this.
No.
Intentionally, Lordship, 159
After
days
vacation
in
only.
custody, we are going to file charge sheet. They are waiting for charge sheet, I think. Lordship, 33 kgs of ganja from the possession of these
Oh,
petitioner.
charge sheet has not been filed.
No. it is at the
Investigation
stage
is
of
going on. We are not going to allow this application.
159 days.
Only after vacation.
No, no.
Then not press. Then
Not
not press.
Two other.
Then not press.
Not-
I'm get now.
Okay.
Lordship, I am for the petitioner. Lordship, 183 days custody,
Sorry?
183 days custody, no recovery from my position, and not present in the place.
No, on the last occasion, your lordship was directed to that point. They have taken that charge sheet was submitted without FSL report. That was the point.
No, that is not recorded in our order.
No, sir, Lordship asked for the
He only
whether
said
charge sheet
there was.
submitted or not. On the last occasion,
Please, when we speak, you please don't talk, huh? He said that there was no recovery from him.
That is there.
179 days in custody as on 16 December. We asked you, inquire and tell us, Mr. Kundu.
That charge sheet.
Otherwise, default bail.
Yes, my lord, charge sheet has already been filed, my lord. On 8/12.
8/12. Then that is fine with the FSL. Then what? What was seized?
1,120 bolts of fentanyl.
Oh, Baba.
Not recovered from my.
But he has, yes.
Not necessary. It's organized crime. Esho. How have you implicated this petitioner? On what basis?
In source information that he is dealing with the this contraband, and when he was fleeing away, in the FIR itself.
Caesar list does not name him.
Kindly see the
Caesar list names him? No.
that is
Then what? The statement of co-accused?
But statement from the police authority.
But kindly see the FIR once, not. But kindly excuse me for the underlying question.
So it's the suo moto complaint.
Yes, suo moto complaint, but he has identified, my lord.
Who identified?
But he knows that person.
So from your personal knowledge, from the personal knowledge of
There is source information, but not personal knowledge.
That's very cool. But something has to be recovered from his position.
But that is
How you have injected it?
later, but so much contraband, my lord. If it is
How much? Okay.
it's 50 bottle, 100 bottle, my lord.
Yeah, the investigation is complete.
Complete charge sheet is submitted with
Yes.
FSL.
How long you are in custody?
183 days.
Recovery কি করে সবার কাছ থেকে recovery সার্ভে কি করে original form এ তুই Their non-recovery does not mean quantity. No, sir. No. Issue. We have heard learned counsel for the parties. Stop.
For the next.
Commercial quantity of contraband items was seized. Stop. There may not have been recovery from this petitioner. Stop. Mere non-recovery per se does not indicate innocence of an accused. Stop. The Honorable Supreme Court has said so in several cases. Stop. Paragraph. Drug peddling is an organized crime. Stop. It is a huge racket in this country and has assumed menacing proportions. Stop. A team operates and it is not always, it does not always happen that recovery shall be made from all the accused persons. Stop. Some of the accused persons operate from behind the curtain. Stop. Paragraph. Commercial quantity of contraband items being involved, comma, keeping in mind the restriction in section 37 of the NDPS Act, comma, we are not inclined to allow the petitioner's prayer for bail, comma, at this stage. Rejected.
Well, 32. In the meantime, co-accused standing on same footing has approached the Supreme Court and Supreme Court has issued notice and has fixed the matter in the first week of January. Can this be after that?
Yes.
10th, my lord, your lordship fixed.
10th.
10th. Because the other matter your lordship fixed on 10th.
On the request made by learned advocate for the petitioner, let this matter be listed again on January 10. বছরটা ঠিক দিও।
My lord, I am for the petitioner. My lord, when I filed the application, that time argument was on. Now arguments have also been concluded.
Yeah. Then not press or what?
My lord, not press, my lord.
Grateful. What was seized?
My lord, 500 kgs of zolpidem tablet, my lord, another zolpidem of 500 kgs.
Best of luck.
With alprazolam and my lord tramadol.
All tablets.
Only.
Medicine dealer.
Chalo.
Medicine dealer.
Not press করেছো তো?
I'm appearing on behalf of the state. I'm led by Mr. Joydeep Biswas.
I for the petition. This is my renewal application. I'm in custody for 1 year, 11 months. Out of 10 witnesses, 1 examined in part. And on last occasion, report was called for and kindly seize the report.
Yes, report.
This is their third application.
Yes, my lord, that I have stated. Lastly rejected on February 2024.
See the report? Defense is taking time repeatedly.
Annex the orders, my lord.
The order does not reflect
I
of
have
the
annexed the all orders, my lord. My lord, up to September 2024, entire order sheet has been annexed.
Up to?
September 2024.
No, after that?
My lord, then may I come back after taking instruction?
Come back. Give him a copy of the report.
Kindly fix this matter after vacation.
Status report file dekho. Status report filed by the state be kept with the records. Stop. A copy of the report has been made available to learned advocate for the petitioner, who seeks a little time to consider the same and come back with better instructions. Paragraph lists this matter once again on 2nd or 6th or 10th.
Any day. It's 6th.
6th. 6th na to 7th, sorry. 7th.
7th.
You know.
I'm for the state lordship, led by 3 years and 1 month I'm in custody. Last occasion, my lord, since my lord 6th and 7th of December was date fixed for trial and evidence, lord, will also adjourn the matter. And on 6th and 7th on both these dates, my lord, the case was adjourned since no witness was present, my lord. My lord, as per my instruction, lordship, this is the report. My lord was pleased to call for a report. My lord, all the
Is that correct? 6th and 7th, no
lordship, I need to take instruction on that point, lordship, but my lord will peruse the report. All the witnesses has been examined except one. No. The next date has been fixed on. 4 witnesses out of 9 witnesses have been examined.
That
is my instruction, lordship.
That was submission made from the bar, sir. Now a written report is being filed. Which one will we accept? Submission was made from the bar.
My lord will peruse the middle portion. I also consulted the learned PP in the charge of learned Special Code NDPS Act, ADJ First Code, Barakpur, North 24 Parganas, and came to know that all the witnesses mentioned in the charge sheet in CW this case, in connection with this case, were examined before the learned code, except SI Avijit Biswas, formally airport such and such of the above referred case. Next date is fixed on 3rd of January 2025 for evidence.
So shall we keep it after the 3rd? Because they are saying 3rd of January, the last witness will be examined.
My lord, so far as my instruction, my lord, I will obtain certified copy to show that 5 witnesses remaining to be examined by the PP, my lord. Date was fixed, no witness was present. That is why the case was adjourned.
Obtain copies. When do you want to come back? Tell us.
My lord, after 3rd, my lord, then my lord, 10th, my lord.
10th. Status report filed by the state be kept with the record. Stop. From the report, it appears that only one prosecution witness remains to be examined. Stop. This is disputed by learned advocate for the petitioner, who seeks a little time to produce certified copies of the orders of the learned trial court. Stop. On his request, let this matter stand adjourned and be listed again on January 10.
Grateful, lordship. Grateful.
Right.
My lord, the report may be kept with the record.
We have taken it. Oh,
36. Lordship, last occasion, as I submitted, Your Lordship recorded my submission.
Mr. Chatterjee, are you available in the second half?
Lordship.
Come back at 2 o'clock. I have an administrative meeting.
Lordship.
দাও আমি তখন প্লেস
but the report says it was the defense who filed an application for closure of evidence. There are 16 witnesses, 12 already examined, only 3 left. All are formal witnesses, the recording officer and the 2 investigating officers.
So it's wrong instructions.
No, Lordship is rely upon the report. Lordship, kindly see first page. No, that is why I am submitting. Lordship, kindly see the first page of the report. As per report, PW 12 CBC such and such examined on 4th July 2024. Right, Lordship? Now, Lordship, kindly see PW 7 examined on 5th July. Now, if PW 12 is examined on 4th July, how PW 7 can be examined on 5th July?
Possible, Mr. Chatterjee.
No.
The order, they can decide in
No,
which
no,
order.
no, no, no. Charge-sheeted witness, any number, when produced in court for examination, he will be PW1.
Okay,
Oh.
So this is the one mistake I have pointed out from the report.
Typographical mistake.
So-
PW মানে একদম সাক্ষীর নাম্বার আছে।
I see, I see.
So this is the one mistake I saw.
CSW becomes PW in trial.
So whether this because if your lordship see the order sheet I have annexed dated 17th of August 2024.
So there was no petition from prosecution for closure of evidence.
That is the subject to correction report is saying.
So let us see
But-
the petition.
Yes.
We ask for production of the petition also.
My lord, it's not with the report, my lord. My lord,
We said if possible, let a copy of the petition for closure be placed before us.
Certified copy.
Obtain a certified copy. Because this is a serious statement to make and aspersion made at least by the petitioner that the prosecution asked for closure of the evidence that was rejected by the trial judge.
and the report speaks otherwise. So
Correct.
the
Report says, yes, a closure application was made, but by the defense. Obtain a certified copy, come back immediately after vacation. Or during vacation.
no,
For lordship subject to correction. As out of 16, 12 has already been examined. And if the closure application has already been dismissed, one IO.
2 IOs.
No, one IO examine হয়ে গেছে তো রিপোর্টে দেখ one IO examine.
Shouldn't take long, shouldn't take long.
So kindly make a
We cannot. Time period, we cannot.
oh হ্যাঁ সেটাও ঠিক.
Expedite, yes, we can.
That lordship
it won't take much time, my lord.
Wait, as per prayer submission.
So আমার ঘাটে-
Latest report filed by the state, be kept with the records. Stop. Paragraph. There seems to be some controversy as regards whether the prosecution or the defense made a petition before the learned trial court for closure of evidence. Stop. However, we need not get into such controversy. Stop. What is not in dispute is that such closure petition has been rejected by the learned trial court. Paragraph. It is also not in dispute that 12 out of 16 charge sheet named witnesses have already been examined. Stop. The trial is likely to conclude on an early date. Paragraph. In view of the aforesaid, we are not inclined to entertain the petitioner's prayer for bail, at this stage. Paragraph. Dismissed. Next. However, in view of the fact that the petitioner is in custody for almost 2 years,
More than 2 years now.
for more than 2 years, we
2 years,
request the learned
8
trial
days.
court to expedite the trial to the utmost and conclude the same as early as possible.
Great.
Without granting unnecessary adjournment to either of the parties.
Great.
Today, we have just seen a direction from the Supreme Court. It is being circulated amongst the judges. In a trial, if witness is there, if lawyer is not there, be it prosecution, be it defense, court will appoint an amicus curiae and proceed.
Lord, in 37, Lord, I will pray for some time. Lord, the reason is,
Yes.
Lord, I have been informed in the morning session, the Lordship dealt with the bail application of the co-accused and his prayer for bail has been rejected. Now, so far I am concerned, the second application for bail, first application was not pressed.
You want it after the vacation?
After the vacation or on Tuesday, whichever date is convenient to you.
This is NDPS. NDPS, we won't have any.
After the vacation,
So you choose your date, Mr. Basu, 2nd November, 2nd January, 7th January, 10th January.
2nd January.
I would make it 10th January because my lord 8 is the date for framing of charge. My lord.
All right, 10th January.
Learned advocate for the state says that January 8 is the date fixed for framing of charge. Paragraph as requested by learned counsel, comma, let this matter be listed again on January 10.
Deep.
Item 38, Lordship, I am praying for not today.
Oh, okay.
Call for a report, my lord. My lord, report is not yet.
So when will you file? 2nd of January?
2nd of January.
May I wait for interim?
Ah. Yeah, more than a year only. What was, how many kilos of gaja?
350 bottles of fancy. Oh.
Come back on 2nd January. The state prays for some more time to file the report that we had called for. The paragraph, let this matter be listed again on January 2, 2025, retaining its position.
My lord, great.
My lord, item 39, kindly keep the matter after vacation on 7.
My lord, case of no recovery. I am in custody for almost 1 year, 6 months. On that score, on the last occasion, your lordship called for a status report. Now, out of 20 witnesses, only 1 witness has been examined.
My lord, report I have, delay was on their ground only.
My lord, kindly seize the report.
Where is the report?
If there is a delay on there, corpus shall not allow.
And it's a case of no recovery.
On
So, my lord, sections are not attractive.
No, recovery is Mr. Chakravarti. Or non-recovery per se is not a ground for saying that section 37 is diluted.
My lord, that has to be with the conscious possession. Here, my lord, a individual person from him seizure has been made. After 6 months, my lord, I surrendered. So I am no way connected with the principal accused.
My lord, there are CDs and bank transactions, several bank transactions with different people from Manipur. The consignment came from Manipur itself.
But they are not accused.
Why are you seeking adjournment today?
My lord, Mr. Basu is appearing. He is out of town.
Mr.
Antarikho Basu.
Just
On the ground of a learned friend, they are seeking. 2nd January, first day.
My lord, 7th. He will return on 6th.
my lord, keep it on.
7th then, 7th January. That is the 2nd NDPS day. 2nd is first, 7th is 2nd.
my lord.
Accommodation is sought for as a status report. এখন file করলো? Status report filed, give a copy. Status report filed by the state be kept with the records. Stop. A copy of the report has been made over to learned advocate for the petitioner. Paragraph, the state seeks accommodation. Stop. Let this matter be listed again on January 7, 2025, retaining its position.
Dada.
My lord, item number 40, I am for the petitioner, my lord. Charge sheet submitted, my lord, without FSL report, my lord. I was arrested on 24th February 2024. Charge sheet submitted, my lord.
One second,
20
one second, one second. What correct? 24th February is
My date of arrest, my lord.
arrest, then
CS was filed, my lord, 20th August 2024.
yes, 2020.
20. That is
Yes.
179 days, my lord.
Date.
20th August 2024.
Yes,
And my lord, I filed statutory bail, my lord, on 25th September 2024.
25.
25th September. 214 days.
And
And my lord,
still
without
not
FSL,
filed, FSL.
Still perhaps still not filed, my lord.
This you filed this 25th September before the trial court.
Yes, 25th September before the trial
Rejected,
court. Yes,
rejected.
my lord.
Issue.
Only, my lord, that interim bail till the
Interim.
till the
Yes.
hearing of the SLP.
The petitioner says that he was arrested on February 24, 2024, stop. Charge sheet was filed on August 20, 2024, i.e., on the 179th day after his arrest,
No.
without the
Oh, acha. Yeah.
without the FSL report, stop. 180 days after his arrest expired on August 21, 2024, stop. He exercised his right to avail of statutory bail by filing a petition before the learned trial court on September 25, 2024, stop. Such prayer having been rejected, he is before us. Paragraph, learned State Council says that the FSL report is still not available. Stop. Paragraph, this bench has held in the case of Idul Mia, CRM ta diye debe, that a charge sheet filed without the FSL report in an NDPS case is not a charge sheet within the meaning of the provisions of the Code of Criminal Procedure. Stop. Hence, upon expiry of 180 days from the date of arrest of an accused, even if charge sheet has been filed in the meantime, but without FSL report, the accused becomes entitled to statutory bail. Stop. So long as he exercises such right prior to the FSL report being made a part of the charge sheet, he must be granted default bail. Paragraph, accordingly, we have to allow the petitioner's prayer for bail. এটা হেন্স করে অ্যাকর্ডিংলি না করে পরেরটা অ্যাকর্ডিংলি হবে। হ্যাঁ, স্ট্যাটুটরি বেল হচ্ছে যা, ডিফল্ট বেলও তাই। ঠিক আছে?
Grateful.
ও এই সরি এই ওখানে লেখো তাহলে হেন্স উই আর, কেটে দাও, ওই হেন্সটা কেটে করো, হেন্স উই আর ইনক্লাইন্ড টু grant interim bail to the petitioner, keeping in mind that the Honorable Supreme Court has been granting interim bail in all such cases as the issue of whether or not a charge sheet filed without the FSL report in an NDPS case is sufficient, is pending consideration before the Honorable Supreme Court. করে ইন্টারিম বেল হবে না, কোথায় চলে যাচ্ছে, কোথায় তারপরে কবে আসবে ম্যাটারটা আবার। Paragraph, let this order of interim bail continue till the end of January 2025, or until further order, whichever is earlier. Paragraph, list this matter on January 28 naki 27 or 2027.
Subject to lordship's convenience, my lord, this interim order may be till the disposal of the SLP, my lord.
No, let us see. In all matters, what we have done now, let us do
All
this.
matters will come back almost in the.
No, একটা bouncer দিয়ে দেখলো।
Grateful.
জানি
Bouncer না, এটা Yorker. Yorker.
Wasim Marker is giving ear cut instead of.
No, my lord.
Next.
Article 21.
My lord, I'm for the petitioner, my lord. Charge sheet submitted without FSL, my lord, but the fact of the case is
Without FSL, no.
yes.
FSL is there.
FSL is there, my lord, but charge sheet submitted, my lord, 172 days. Within 180 days, FSL was not there in before the learned trial court, my lord. Though this is my renewal application, my lord, but then when lastly rejected before your lordship, my lord, then my lord, Idul Mia was not decided by your lordship, my lord. That is on 8th
So
July
one second.
He never exercised his.
Yes,
That's the question.
172 days charge sheet.
Without FSL
No
report.
FSL, very well.
Yes, my lord.
Then when was FSL filed?
FSL in the month of supplementary charge sheet.
September, July 2024.
Yes.
September, July, here's the one.
9th July 2024.
9 July 24, FSL report filed by way of supplementary charge sheet.
Yes, my lord.
And when did you apply for bail?
Before that, my lord, 16th May 2024. 16th May.
Where?
I preferred bail.
Where?
Before the learned trial.
Was after 180 days.
No, my lord, within 180
Then
days.
that would not do.
But my lord,
That is not exercise of
as
right
my
of
lord, the charge
statutory
sheet
bail.
was not within 180 days, my lord. So automatically my right to statutory will crystallizes, my lord.
You have to exercise that right upon expiry of 180 days.
As my lord, this is statutory right, my lord, subject to correction from your lordship, my lord.
Yes, but you have to exercise that. You don't need to file an application for that.
But I have preferred, but before 180
have
days, my
preferred
lord,
not-
and that have
You were
hindsight-
not exercising the statutory right.
No, my lord.
You were praying for bail in exercise of the discretionary
Discretionary
power
power.
of the court under
Yes.
439.
But in that application also, my lord, I have mentioned that FSL was not submitted with the charge sheet, my lord.
What do you
and-
want to do? We are going to dismiss it.
My lord, not pressing this application.
Very well.
Grateful.
Not pressed.
Grateful, my lord.
না এটা 10 তারিখে না, এটা আমি আজকে বলবো কারণ 10 তারিখে বইটা
How many years? How many?
My lord, I'm for the respondent, my lord.
How many years?
My lord, in item number 26, my lord, your lordship fixed a date for hearing on 10 January, my lord. Identical matter.
Very well. Lekho,
Is a co-accused.
learned advocate for the petitioner says that the bail petition of a co-accused being CRM NDPS 1715 of 2024, correct?
Yes.
Has been directed to be listed on January 10, 2025, stop. On his request, let this matter be also listed on January 10, 2025, immediately after the other matter. Kaushik, duto porpor.
Grateful.
Yes. My lord, I'm for the petitioner. My lord, on last occasion, lordship
Not the
please to
original,
call for
if
the.
he was called for to see whether the report was filed before charge sheet or not. The report was available before the charge sheet. my lord.
Before charge
It is noted, my lord. You also see. Reporter ছিল, তারপরে charge sheet হয়েছে। Charge sheet was filed on 27th of March. Prior to that, my lord. My lord, and charge sheet was filed on 27th of March.
It was filed with the charge sheet.
My lord, and my lord, apart from that, I'm in custody for 1 year.
60 kgs
24
ganja, my lord.
1 year only.
Only
one. What is the status?
Only charge has been framed.
How many witnesses?
My lord,
16.
What was recovered?
60.845 kgs ganja.
We'll only expedite, Mr. Gupta, or yes.
My
Read order dated December 5, 2024. Stop. Paragraph. The original case diary is produced. Stop. We find that the FSL report is dated February 12, 2024, and the learned trial court considered the same, and the same was filed with the charge sheet on March 27, 2024. Hence, no question of the petitioner being granted default bail on the ratio of the decision in Idul Mia, does arise. Paragraph, the petitioner says that he is in custody for more than 1 year. Stop. Beyond framing of charge, nothing has progressed in the trial. Stop. There are 16 charge sheet named witnesses. Stop. Paragraph, the state says that 66, how much ganja?
60. 60 kgs.
60 kgs of ganja was recovered from sole accused.
No, 2 persons.
From the accused persons, including this petitioner. So, paragraph, in view of the restriction in section 37 of the NDPS Act, we are not inclined to grant bail to the petitioner. Stop. Paragraph, however, considering the period of detention of the petitioner, we direct the learned trial court to spare no efforts to expedite the trial to the utmost and conclude the same on an early date. তার আগে এটা এর আগে প্যারাগ্রাফটা ডিসমিস করে দিও, করে তারপর এটা বলো।
I'm for the petition. Below commercial quantity, 3.35 kg of ganja was recovered. My lord, these are the orders, my lord, of the persons on the same date. My lord, 7 kg ganja was recovered from another lady. She was granted bail by the coordinate bench. My lord, I was supposed to place that order before your lordship today. My lord, in this case, charge sheet also submitted. 97 days I'm in custody. The statutory period was 90 days. 37 will not act as bar.
My lord, that subject to correction, my lord, submission made by my learned adversary is that bail has been granted to the person in a similar circumstances where arrest has been made on the same day. The bail was granted on the consideration that there was a upcoming marriage ceremony, my lord.
That's not reflected in the order.
Yes, that is not really reflected, but that could be found out from the application, my lord. That
Not necessary, madam.
My lord.
Even without marriage or onnoprashan,
My lord, my lord, my lord.
intermediate quantity,
That under that,
your charge sheet has been filed.
my lord.
Then investigation is complete. The petitioner is in custody for
97 days.
97 days. Stop. She says that she has been falsely implicated. Stop. She prays for bail. Paragraph. Learned advocate for the customs authority opposes the prayer. Stop. She submits that 3 kgs in this case,
3.05, 6 grams.
about 3 kgs of ganja was recovered from the petitioner at the Calcutta airport
My lord.
when she was returning from Bangkok.
My lord.
Stop. Paragraph. We have considered the material on record. Stop. The amount of narcotics recovered is of intermediate quantity. Stop. The petitioner does not have any criminal antecedents. Stop. Charge sheet has been filed upon completion of investigation. Paragraph. Under those circumstances, we are inclined to allow the petitioner's prayer for bail. Accordingly, করে আমাদের তো ইউজুয়াল যে কন্ডিশন আছে আমরা 25,000 দিই না NDPS এ 25,000
থানা ফানা হারিয়ে
না ও তো রিপোর্ট করবে না কোথাও ভদ্রমহিলা রিপোর্ট করতে হবে
চার্জশিট হয়ে গেছে
রিপোর্ট করা দরকার।
My lord, I am appearing for the respondent lordship.
For the petitioner, man.
Respondent.
My lord, almost 3 years, man.
My lord, there, in the last occasion, there was a direction to file report by the NCB, my lord. I am filing my report, lordship.
ও এনসিবি এখানে
My lord, kindly see, my lord, page 50, my lord, at once.
3 years.
3 years, my lord. My lord, Honorable Apex Court granted bail to the co-accused.
Yes.
why 3 years it's recorded 2 years 4 months
No, my lord. My lord, now,
in the last order it is so recorded
this, my lord, my lord, I am in custody since, my lord.
13th December this bench was not available
My lord,
তুমি জয়ের সঙ্গে বসেছিলে
The prisoner is custody for 2 years 4 months.
no, my lord.
My lord, he has been granted several instances.
When he have been arrested.
See, my lord. My lord, on 4/3/2022,
4/3/2022.
2 year 10 months, my lord. 10/11 month.
Okay. Now what is the stage of the proceeding?
My lord, they have already found, my lord, 400 kg of ganja. And the Honorable High Court directed trial court to fix such schedule consisting of 3 dates, and they are rescheduling dates on every 45 days, lordship. And another is he used juvenile for illicit trafficking of ganja, and the crime also needs to be considered in purview of 32B of the NDPS Act, lordship.
Charge has been framed.
Yes, my lord.
My lord, out of 5 only
Minus
2 examples.
weakness of PW3 already completed, lordship.
What is
And
deposition? Show us the deposition.
I have no such copy of deposition.
There is no incriminating statement which shall that you
3 out
Can
of
see page 53 at once. There is a direction passed by the coordinate bench of this honorable court to conclude the trial within a period of 6 months, my lord, from the date of recording evidence. That the time period is already been over.
my lord, he
Can you
has
see, my lord, page 53 and page 54.
my lord, he has been given several times of bail, and he absconded, which caused inordinate delay.
Oh, you have granted bail.
Several times.
You have granted bail.
No, my lord.
Please saying so.
I mean, still in custody since 2022.
They are saying in the report, my lord, kindly come to
Still
the
I am in
last
custody.
paragraph, lordship. Department is saying on the report itself, kindly come to the last paragraph, lordship. There has been several instances where accused person got bail from the court and absconded, which caused inordinate delay in the trial. Since he was involved in illicit trafficking on narcotic drugs and
madam
was
don't read the status report we can read it how do you show that this petitioner absconded the accused person means there are several accused persons
my lord.
how do you know that anyway 3 out of 5 already examined show us from the 3 depositions that you are not implicated by the witnesses we'll release you otherwise no because the trial is coming to an end.
And in the meantime, my lord, honorable Apex Court granted bail to the co-accused. My lord, can you see the
Only next date is 13/1/2025.
My lord, can you see page 50 at once?
Then we will dismiss it today itself. What is the word?
No, I have a question. On 24th April, there are already 2 examined. For last 6 months, you have examined only 1 witness.
Yes, ma'am.
Clarify this.
My lord, then I have to come back with the further instruction, lordship.
On this code, note 2 out of 5 have already been examined.
Oh.
Next schedule is fixed on 2nd.
My lord, then I have to come back with further instruction, lordship. Kindly.
If you are not ready, we are not here to allow you any prayer for the time.
3 years, you said?
Yes, ma'am.
Almost 3 years.
Almost 3 years.
My lord, next date is 13th January 2025. Next date is 13th
Can you
January.
show us the Depositions.
My lord, now, my lord,
Tell us when.
in the month of January, otherwise,
Wait, 2nd January,
yes, my lord, 2nd January, not possible.
After 13th.
7th January, or after immediately after 13th. 16th,
My lord, after 5, I submitting, my lord.
after 5th
5th
January.
January.
7th January, 7th January.
Yes.
The petitioner, status report filed by the state, we kept with the records. Stop. It appears that 3 out of 5 witnesses have been examined. Stop. However, it appears that after the rejection of the petitioner's prayer by the coordinate bench, when was it rejected?
My lord, on page 53, my lord, on
April
25th
25, 2024, only one witness was examined by the prosecution. Stop. Therefore, the trial is proceeding at a snail's pace. Stop. The petitioner is in custody for a little less than 3 years. Paragraph, we would like to see the depositions of the 3 witnesses already examined by the prosecution to assess as to what extent those witnesses implicate this petitioner. Paragraph, as requested by learned advocate for the petitioner, let this matter stand adjourned and be listed again on January 7, 2025, to enable him to produce certified copies of the depositions.
My lord, one in lordship, there may be the PW3 already completed, lordship.
We have said 3 out of 5.
One.
PW3 is going on.
Have you gone
For
through
my instruction is concerned, my lord, PW3 is going on
please,
since 6 months.
have you gone through the order dated 24/4/2024?
No,
On
my
that day, already 2 have already been
Yes.
examined. Thereafter, only 1 witness has been examined.
ठीक है. Come back on the 7th.
Yes.
Grateful, my lord.
For the petition. From the possession of the petitioner, Article 6, but he is in custody for 1 year, 9 months, and 15 days. Total 17 witnesses cited in the charge sheet.
Knowing
It was
fully
told
well,
that 3 remain.
so from your position.
Yes,
So knowing fully well that if you apprehend, you may have to undergo 3 years, 4 years in custody. Fully well you possessing all this.
I don't have the copy of the deposition. So once they state
23 matter.
23?
Case of 2023.
What was recovered?
Fentanyl.
620 bottles.
To just 10 is commercial, above 10. You want to bring the depositions?
And let the trial be speeded. Only 3 witnesses
Was left. Very well. Commercial quantity of fentanyl syrup containing codeine phosphate was recovered from the possession of this petitioner. Stop. Keeping in mind the restrictions in Section 37 of the NDPS Act, we are not inclined to allow the petitioner's prayer for bail, at this stage. Paragraph. Dismiss করে দাও. Next. The petitioner says that he is in custody for
1 year, 9 months, and 14 days.
for more than 1 year, 9 months. Stop. Only 3 out of?
Only 3 remain.
Only, 3 witnesses remain to be examined.
Out of 17.
3 witnesses out of 17 charge sheet named witnesses remain to be examined.
There is no delay.
Paragraph. Considering the prolonged detention of the petitioner in judicial custody, we request the learned trial court to expedite the trial and conclude the same on an early date.
My lord, 146 days, no recovery. My lord, from whose possession it was recovered, they are acquitted. This is a case of Yes, ma'am.
May I
There,
supplement?
this is the case of
He
2000.
absconding for 7 years.
7 years.
But the trial is not delayed for that.
The judgment has been passed on 23rd of August 2021. He arrested on 18th of July 2024. Today's date for evidence of their.
No, that is different issue. The contraband article recovered from some
Yes.
person.
This is a case of no recourse.
That trial,
They are acquitted.
and they are acquitted. How you prove?
Elevator.
Then,
Clear, clear.
for the petitioner has submitted that petitioner is languishing in the judicial custody for about 146 days. The accused from whose custody contraband articles were recovered have been acquitted in the relevant trial proceeding. Stop. There is no chance of success for the prosecution in this case also. Stop. He may be released on.
No recovery.
There was no recovery of contraband articles from this accused. Stop. The petitioner may be released on bail on any condition. ये accused का बोला और petitioner को. ठीक है जी. ठीक है. The learned counsel for the state opposes the prayer for bail. According to him, the petitioner absconded for more than 7 years, and for which the trial could not be proceeded against him. Stop. We have considered the materials on record. It appears that other accused persons from whom contraband articles were recovered.
Page 6. Page 6.
Were acquitted in the relevant trial proceeding. Stop. Nothing was recovered from the present petitioner. In view of such materials on record, we are inclined to allow the prayer for bail on certain conditions.
Remain in Murshidabad or.
Yes, but it will record. We are of the opinion that the restrictions in Section 37 of the NDPS stand diluted. We are inclined to. Yeah, you want to put this. No, you can follow the request.
My lord, this is renewal of my prayer, my lord. My lord, case under section NDPS, under NDPS chapter, my lord. My lord, 24 kg, my lord, recovered from joint position. My lord, till date, I am in custody 1 year, 2 months, 22 days. My lord, at the time of filing of the charge sheet, there was no chemical report. Subsequently, my lord, no chemical report. My lord, as per my instruction. And my lord, after the filing of the charge sheet, my lord, supplementary charge sheet probably, my lord, has been submitted. My lord, I have filed the application 8th of November 2024. This bail application. So, my lord, at the time of filing of this application,
Arrested when?
my lord, arrested my lord on 14th of September 2023.
14th of September.
Yes, my lord.
2023.
Charge sheet filed?
11th March 2024. 17 witnesses were proposed to be examined.
Yes.
Till date, not a single witness. Charge has been fixed.
Without FSL report.
180 days expired when?
My lord, 180 days, my lord, 12th of March 2024.
And you applied for bill?
My lord, this is a renewal. My lord, this application, my lord, 8th of November 2024.
2024. So when FSL report has not been submitted? When?
My lord, on 6th of March 2024.
5th of March দেখাতে পারে
6th of March?
6th of March 2024.
Yes.
Oh, my lord.
Then
I don't know. My lord, then, my lord, the next argument, my lord, the delay in trial. My lord, 1 year, 2 months, 23 days is a lady, my lord.
yes,
17
what
witnesses.
is the stage?
17 witnesses. Now let us call for a report, my lord. All the witnesses.
Status report, status report. Gaurav.
The learned counsel for the petitioner has submitted that petitioner, being a lady, is in custody for about 1
My lord,
year.
1 year, 2 months, 22 days.
22 days. Yeah, that one day. Okay, stop. He enlarged on bail on any condition. Stop. Para. The learned counsel for the state wants to submit a status report. Let such status report be filed before this court indicating how many witnesses the prosecution proposes to examine to prove its case against the petitioner, and within time the prosecution expects to complete the trial. Okay. This is another point.
This is what we. Second or seventh? Seventh. Seventh.
Second, I'm no problem with it. Second, second time.
Second. कब बोलते शायद शायद बोलते seventh.
My lord, that is off the record. Yesterday, I told my daughter this person is slow.
India, 618 grams of heroin. Okay.
Dates लिखो.
I was arrested on 28th April 2023.
28th April 2023. Then
19th October 2023, charge sheet was submitted on 175 days without FSL.
180 days.
180 days, my lord. 24th October 2023.
24th October
2023.
You applied
24th September 2024, my lord.
trial court or this court?
Trial court.
24th October.
24th September 2024, my lord. I'm in custody, my lord, 1 year, 8 months.
So if you arrested April, if you arrested in the month of April, 180 days will completed in the month of October. Why?
Yes. My lord, but 180 days completed in the month of October, but the charge sheet submitted, my lord, without FSL report.
You have said that 180 days completed 24/9. Is not 9.
No, 24/10.
24th 9 2024, I preferred, my lord, statutory bail before the learned trial court. That is 24th September 2024, my lord, I preferred statutory bail.
180 days, 180 days, आगे तो charge sheet on 18th October.
19th October.
24/9
My lord, that is 2024 and 2023.
24/9.
I'm saying again, 19th October 2023, my lord, charge sheet submitted.
175 days.
175 days, my lord. I preferred bail, statutory bail before the learned trial court, my lord, on 24th September 2024, my lord.
Yes.
Till date, charge sheet has FSL has not been submitted.
FSL report has collected my on 14th November 24.
Yeah, much later.
Supplementary charge sheet has been submitted.
But much later, his right accrued, he exercised the right. The trial court rejected, therefore he is before us.
Asun.
The petitioner was arrested on April 28, 2023. Stop. Charge sheet was filed on the 175th day, 175th day after his arrest, i.e. on October 19, 2023, but without the FSL report. Stop. 180 days from the date of the petitioner's arrest expired on October 24, 2023. Stop. He says that he immediately became entitled to statutory bail since the FSL report was still not on record. Stop. He applied before the learned trial court on September 24, 2024 for default bail. Stop. Such application having been dismissed, he is before us. Paragraph. Learned advocate for the state says that The FSL report was collected on?
My lord,
FSL report was collected on
my lord, on 14th November 2024.
24. It has been filed now.
My lord, supplementary charge sheet already filed, my lord, 27th November.
Stop. By way of supplementary charge sheet, comma, the FSL report was filed before the Learned Trial Court on November 27, 2024. Stop. Paragraph. Once the right to avail of default bail accrues to an accused, comma, and he exercises such right, comma, subsequent filing of the FSL report would not defeat such right of the accused. Stop. This would follow from several decisions of the Honorable Supreme Court and our decision in the case of Idul Mia. CRM number ta diye diyo, huh?
But my lord, trial in
Such and
progress,
such.
my lord. PW1
Not following. We have no choice in the matter, sir. It is not our discretion anymore. Stop. Stop. Admittedly, the petitioner exercised his right to statutory bail prior to the FSL report being brought on record as part of the charge sheet. Stop. As has been held in Idul Mia, comma, a charge sheet filed without the FSL report is not a charge sheet within the meaning of the provisions of the Code of Criminal Procedure, comma, 1973. Paragraph, in view of the aforesaid, comma, we are constrained to allow the petitioner's prayer for bail.
My lord,
I am repeating.
I am the partner of a transport company, Prasad Transport. Way back in 2018, Indian Oil Corporation, they requisitioned for lorries for carrying LPG cylinder from Hondia dock to Dibrugarh, Guwahati, Silchar, those areas in Assam, 2008. My lord, I supplied the lorries, my concern. My lord, that carried on. The work order was renewed again for 2 years in 2023 also. I have annexed those documents. But now on 16th, one of the lorries so supplied is intercepted by the police.
16th
of September 2023. One of the lorries is intercepted. And from that lorry, the driver Khalashi, and from their possession, 30 kgs ganja is. Now, I am the person who supplied the lorry, but I was neither found, I was not, obviously, my lord, since I am a transporter.
You are the owner of the truck.
I am the owner of the truck. I supplied. Now, the truck, now I have annexed the documents. On the previous day itself, also, pursuant to all the work orders, the challans, the bills, the petrol pump bills have been, the lorry was carrying those LPG cylinders from Hondia to Guwahati. Guwahati office it was delivered. Again, a permit was issued for carrying cylinders to places in North Assam. Your Lordship, page 33 onwards, all those. Indian Oil Corporation. In the meantime, these people who are the Khalashi and the driver, they loaded the ganja and that was intercepted. And I applied for anticipatory bail, that was rejected. I have surrendered voluntarily on 22nd of July 2024. I'm in custody for more than nearly a little short of 5 months.
This Khalashi and the driver are not your employee.
My lord, they are my employees. But I had no knowledge that this was done because 5 years I am carrying on with this business.
Criminal antecedent?
Lordship, criminal antecedent I did not find, but Lordship kindly says here for anticipatory bail has been turned down.
That he said so.
Lordship kindly says the order. Certain observations has been made. I shall rely on those.
Have you annexed that order? Anticipatory rejection? No.
That has not been annexed.
Why? Anticipatory bail, that initial stage of investigation.
No,
After
not only that, Lordship kindly sees some observations have been made. Why anticipatory bail has been turned down?
Yes. Before asking the owner, entered into contract window.
Who is Prakash Roy? Co-accused? Rejected?
They were found, they were in the lorry. Prakash, Manoj, Sarkar, Rajkumar joined.
Gautam Prasad.
They were found in, I am the owner, Gautam Prasad.
Constructive position what this at this stage.
Constructive position.
The lorry is mine. Now the lorry is on the previous day. The Lordship see, 16th the offense, 15th the lorry is in Guwahati. How can I have constructive position?
How long have these Kalashi and driver been working with you?
That I have to take some insurance. That's
Why would suddenly they do something?
these keep on rotating. These are on rotation basis. And your Lordship sees.
There's no such criminal antecedent.
No.
That I didn't find.
Huh?
That I didn't find in the CD. If your Lordship so desire, I can take instructions.
He used to be doing
So how long you have employed those?
Well, these are on rotation, driver and Kalashi. Many lorries we have. These 10, 11 lorries we have.
in custody?
These were given to IOC.
Custody since
And there are
22nd of July.
4.5 months, few days short of
Not
5
very much. Charge frame, not it. Not
Nah.
Lordship, date has been fixed. For evidence, yes, charge has been framed. Next date is fixed on 21st of January, 23rd of January, and 24th of January.
How many witnesses?
For evidence, only 11.
37 restriction, in this Chief Justice Chandrachud, in this recent Nawaz Khan also, we have to record a finding that we have reasons to believe your client has not committed the offense.
I'll come to it. Nawaz Khan, there was a Nawaz Khan, there were 2 cars and both the
We
cars
are-
were
we are-
following each other and there was CPR between those.
Mr. Meter, we are not on the facts. We are on the,
Nawaz Khan has its own ticket.
not on the facts.
Here your Lordship comes to page 34. Show.
Too
The
early.
lorry was not even in my control or position because on page 34, it was on Guwahati on that day and it was delivering the LPG cylinders.
All these
Again,
points you
LPG
argue.
picked up on 15. 16, the lorry is arrested.
About a rejection.
Anticipatory bail. Not bail. Bail first time. And charge sheet filed,
Suffer.
everything done.
Suffer a rejection today.
My lord, and my lord, not in possession. And only what is based is the statement of the co-accused. I do not know even if that is there.
No,
Whatever.
my case is
I
equal.
am the owner. But my lord,
That is
I
my
will
only-
give a very practical example. Yesterday, I had sent my driver and my car to one of my learned friend's house for collecting no lane good.
Oh.
Yes. I'll be very honest, my learned friend is in court also here now. But be that as it may. My lord, if something happens, my lord, later. My lord, will I become responsible?
That's
That
why
is the problem.
Prima facie, yes.
That's why I have asked him whether there is any criminal antecedent or no.
Prima.
To that extent also.
বড় কি করবে দেবে তো দিয়ে
Lordship, date has been fixed for evidence.
So he is the owner.
He is the owner.
That fact cannot be diluted by
Yes.
any
Yes,
evidence.
yes.
If he on the basis of such document or on the basis of such evidence, he can be convicted afterwards. There is no problem.
For 37.
But there is no. Okay,
37.
okay, that is on my dictation. That is
Only 4
depend-
months custody. Date has been fixed for evidence.
Why is the criminal
Charge sheet,
antecedent?
supplementary charge sheet.
Why is the criminal antecedent?
Lordship,
For 11 years or 5 years, he is.
then Lordship, kindly adjourn it. I shall take instruction.
No adjournment. That counsel for the petitioner has submitted that petitioner is in languishing in the custody for 5 months. Nothing has been recovered from his possession. However, he is the owner of the concerned vehicle.
I was in
from
chair and
which
come my driver.
the
That's it, 4 months.
Hey, Anusha.
Oh, 5 months, no? Something. Scholarship is called.
From which the contraband articles are recovered. The driver and Khalasi are responsible for possessing such contraband articles. He has no role to commit such crime. No. He has been Oil Corporation for about 5 years. Any premises. So, as the investigation is complete, witness action is going on.
So say the witness date has been fixed.
As the charge for proceeding came, he may be enlarged on bail on any condition that there is no chance of his absence. Stop. Clear. The learned counsel for the state opposes the prayer for bail vehemently. Brought to your notice the order, the relevant order by which the prayer for anticipatory bail of the present petitioner was rejected on the ground that he was in the constructive possession of the contraband article. Stop. The learned counsel for the state has also against petitioner is enlarged on bail, the prosecution may suffer. Stop. We have considered the materials on record. It appears that the petitioner has been doing business with the Indian Oil Corporation for about 5 years, and there was no criminal antecedent of the petitioner. So, as the materials on record is sufficient to show that he is the owner of the vehicle, may be convicted on the basis of documents. However, so far as this present stage is concerned, it appears that investigation is complete, and as there is no criminal antecedent of the present petitioner and who has been doing business with the Indian Oil Corporation without any blemishes, I think that the restriction under section 37 NDPS Act stands diluted for at this stage. As the investigation is complete and there is no criminal antecedent of the present petitioner, also taking into consideration that the contraband article are not recovered from his immediate possession, I am inclined to allow the prayer for bail of the petitioner on certain conditions. Shall read the where is he is residing? He's residing where?
Assam.
Assam.
Company is Assam. Distribution Assam.
And case is pending where?
Krishnagore under special court Krishna.
He shall remain with jurisdiction of Krishnagore PS and shall meet the OC Krishnagore PS once in every week. How many witnesses? 8. 11. Okay. For next 9 months. Huh? No, for next
In the conclusion.
until further order. Till the conclusion. Until further order.
And so far as
You granted bail?
No, so far as Nolenburg, the offending person is there.
Yes, sir.
I am diabetic.
So what is the contraband article?
Nolenburg and more. And I am diabetic. So I don't get
That
anything.
is why
And
the
managed to
craving is
force,
more.
threaten her.
Only
force her.
diabetic persons have all these cravings.
Oblige.
Item 51. Lordship, in this matter, I am relying upon your Lordship's decision of Idul Mia and Habibur Rahman.
Habibur Rahman.
That present application can be considered as statutory bail application because till date chemical report has not been submitted.
But you have filed the present application after 180 days.
After 180.
Give us the dates.
Lordship, arrested on 29th February 2024. CS charge sheet submitted 14th August 2024. 180 days expire on 29th August 2024. And I filed this application before this court on 12th November 2024. Till date, the chemical report is not available.
Is that correct? Your ratio. The petitioner says that he was arrested on February 29, 2024. Stop. The charge sheet was filed on August 14, 2024, but without the FSL report. Stop. 180 days from the date of the petitioner's arrest expired on August 29, 2024. Stop. On November 12, 2024, the petitioner filed the present application for bail. Stop. The FSL report is still not on record. Paragraph. Learned advocate for the state, while opposing the prayer for bail, in her usual fairness, says that it is true that the FSL report is still not available. Still not available. Stop. Paragraph. Available. Stop. However, commercial quantity of contraband items was recovered from this petitioner. Paragraph. As has been held in the case of Idul Mia, CRM number to the other way, a charge sheet filed sans SANS. Sans the FSL report is not a charge sheet within the meaning of the provisions of the Code of Criminal Procedure, 1973. Stop. Even if such an incomplete charge sheet is filed within 180 days from the date of the accused person's arrest, upon the expiry of 180 days, the accused person becomes entitled to statutory bail. Stop. Paragraph. In the present case, the incomplete charge sheet was filed on August 14, 2024. Stop. Upon the expiry of August 29, 2024, a right of availing of statutory bail accrued in favor of the petitioner. Stop. He exercised such right by filing the present application. Stop. The present application may be treated as an application for exercising the right to obtain statutory bail, as has also been held in the case of
Lordship Habibur Rahman, CRM NDPS 1663 of 2024.
পেয়েছো ভুলভাল দিও না, জিজ্ঞেস করে দিও।
Once আমি লিখে দিই।
Stop. Admittedly, the FSL report is still not on record. Paragraph, in view of the aforesaid, comma, we are constrained to allow the petitioner's prayer for bail.
Grateful.
After vacation.
Lord, I'm appearing on behalf of the NCB, my lord, filing of the report.
File the report. Report filed by, give them a copy. Report filed by Narcotics Control Bureau. We kept with the records. A copy of the report has been made over to learned advocate for the petitioner. Stop. Paragraph. The petitioner seeks accommodation. Stop, as requested, comma, let this matter stand adjourned
14 January, Your Lordship.
and be listed again on January 15.
The 53, my lord, is on the point of statutory bail only, my lord. It is just a matter of record. I have annexed every document, my lord. If my lord would kindly.
My lord, probably less I say, better it is today.
Yes, give us the dates. Give us.
I have made a short note for your lordships.
My lord, I'll give your lordship the dates.
My lord, on 22nd of February, I was arrested. Thereafter, on the 180th day, on my lord, 1st of August, the charge sheet was filed without, my lord, the FSL report. On 12th, I make a prayer for statutory bail, which was turned down 12th of August. I have approached this court in the first week of November. Thereafter, my lord, the supplementary charge sheet has been filed only on the 27th of November. I am in custody for, my lord, about 10 and my lord, 10 and a half
9th,
months.
supplementary is filed on 9th of December.
9th of December.
Not 27th.
9th of December.
My lord.
You say 28th of November.
My lord, the order sheet I have, my lord.
My lord, we've got the charge sheet.
No, doesn't matter. We'll anyway after the.
Anyway after, my lord.
Issue. The petitioner was arrested on February 2, 2024
We did now.
for allegedly possessing commercial quantity of commercial girda, allegedly possessing narcotic drugs. Stop. The charge sheet was filed on August 1, 2024.
My lord, his dates and my dates are not.
37 is the date of the charge sheet filed on the first.
30th, my lord, my date is 30th of July 2024. My lord, otherwise he will get, but only, my lord, the dates I'm just.
It will be 30th, my lord.
Yes.
Then also I'm covered.
The charge sheet dated July 30, 2024
My lord.
was filed on August 1, 2024, but without the FSL report. Stop. 180 days from the date of petitioner's arrest expired on
my lord, 1st of August 2024.
Expired on August 1, 2024. Stop. The petitioner applied for statutory bail before the learned trial court on August 12, 2024. Stop. Such prayer having been rejected, the petitioner is before us by way of this application, which was filed on November 12, 2024. Stop. Paragraph. Learned State Counsel, while opposing the bail prayer, says that supplementary charge sheet has been filed with the FSL report on
My lord, 9th of December 2024.
December 9, 2024. Stop. The next date has been fixed by January 6, 2025.
My lord, for framing of charge.
Has been fixed by
My lord,
the
for awaiting report, my lord. Not for framing of charge, because my lord, the co-accused is absconding.
is the next date fixed by the learned trial court.
I have the order sheet.
Stop.
Awaiting report of the-
Paragraph. It is therefore clear from the facts recorded above that the charge sheet comma, though filed within the statutory period of 180 days, comma, was not accompanied by the FSL report, stop, immediately upon expiry of 180 days, comma, the petitioner became entitled to statutory bail going by the decision in the case of Idul Mia, rendered in CRM such and such, stop. The petitioner exercised such right by filing an application before the learned trial court, stop. Suffering a rejection there, comma, the petitioner is before us, stop. After the present application was filed, the FSL report has been brought on record before the learned trial court by way of supplementary affidavit, stop. That would not, however, comma, affect the indefeasible right to avail of default bail that accrued in favor of the petitioner earlier, stop. Paragraph, hence, comma, we are constrained to allow the petitioner's prayer for bail.
My lord, only as an officer of the court, my lord, may I just point out, my lord had dictated as supplementary affidavit, should be supplementary charge sheet, subject to what?
Supplementary charge sheet.
Subject to what?
What do you expect at the end of the day on a Friday? Supplementary charge sheet.
Deeply obliged, my lord.
এটা তোমার বলা উচিত, তোমরা কেন মনে করাবে?
Grateful.
Clarification চাই। But some clarification is required because the some portions of the CD are illegible. Well, I can't read. So
what do you propose? Tell us. What do you want?
I'm praying only for not today.
Which means 2nd of November, 2nd of January.
Lordship.
The state seeks a day's accommodation. Stop. Let this matter be listed again on January 2.
Idul Mia.
My lord, in this matter, Mr. Nirupam Dhali is appearing for the statement that I'm praying for only not today.
My bad.
Not today.
My lord, deeply obliged.
Yes, Mr. Mahatro. My brother is saying the new year will start with ganja.
Every possible thing under
2nd January, yeah.
56 I am appearing.
I am for the petition praying for not today.
Earlier also time was taken.
3 minutes left.
They are in custody. They are not.
This is not their lucky year. They want to do it next year.
I think so.
Not today.
7.
My lord, I am for the petition.
Lordship, praying for not today. Learned senior is engaging in some other.
Not today means 2nd January.
Not this year.
Hmm?
Not this year.
Not this year.
2nd January.
My lord, I am for the petition. My lord, on last occasion, the state prosecution assured that within 4 months trial will be concluded. That is going to lapse by tomorrow. And my lord, till date only.
Where is this such assurance recorded?
My lord, I have kindly comes to page 12 of my application.
আমাদের অ্যাসিওরেন্স নয় ভাই সেটা অন্য
Yes, Miss Sinha. What is the stage?
Only 2 witnesses have been examined, my lord.
Out of 13?
My lord,
Yes.
out of 13.
How long you are in custody?
Like 2 year, 8 months, 4 days.
2 years, 8 days. The petitioner renews his prayer for bail. Stop. He had earlier approached He na she.
My lord, she.
She had earlier approached this court praying for bail by filing CRM NDPS 1117 of 2024 stop, by an order dated July 16, 2024, this bench had dismissed such application. Stop. However, we had recorded in the order the statement made on behalf of the state that the trial would be concluded within 4 months. Stop. Hence, we had directed the learned trial court to expedite the trial and conclude the same as soon as possible, and preferably within 4 months from the next date fixed for recording of evidence. Paragraph. The learned advocate for the petitioner says that the time period so granted would expire tomorrow. Stop. However, the trial is far from being concluded. Paragraph. Learned state advocate files a status report. Stop. Let the same be kept with the records. Stop. It appears from such report that only 2 out of 13 charge sheet named witnesses have been examined so far. Stop. The petitioner is in custody for about 2 years, 8 months. Stop. The pace at which the trial is progressing indicates that there is no possibility of an early conclusion of the trial. Stop. An under trial cannot be kept in incarceration for an indefinite period of time without taking the trial to its logical conclusion within a reasonable period of time. Stop. The delay in the present case cannot be attributed to any appreciable extent or at all to the petitioner. Stop. Paragraph. In view of the aforesaid, without touching the merits of the case and solely on the touchstone of Article 21 of the Constitution of India, we feel impelled to allow the petitioner's prayer for bail. Accordingly, blah, blah, blah.
Grateful.
Yes.